Welcome back to the September 27th Board of Oil, Gas, and Mining meeting. We'll start off with docket number 20, we are on the record. We will start off with docket number 2023-023, cause number C0250005-NOV-CH04182023-1 in the matter of Alton Coal Development LLC's petition for review petition for hearing of notice of violation regarding disturbing land outside the permit area of the Coal Hollow Mine, Kane County, Utah. This item was actually heard before a hearing examiner, Mr. Hansen, who I believe cannot be present today, and a stipulation was agreed, and it was also agreed, I believe, to dismiss the request for further agency action, but we'd like to hear the details on that, so I'd now like to call for appearance of counsel.
Elizabeth Harris with the Attorney General's Office for the Division of Oil, Gas, and Mining.
Good morning, Mike Begley, Assistant Attorney AG, counsel for Mr. Hansen, the hearing examiner.
And who is appropriate to start off in this on this issue, do you think?
I believe I was going to give a brief overview, just kind of lay out the facts. Jim Allen represents Alton Coal, and I believe he was going to try and come in on the electronic, but I don't know if he has made it or not, so if he is connected in or not.
Mr. Allen, are you with us electronically?
I do not see him in the meeting.
Okay, well.
Thank you.
I'll just give a brief overview of this action. Coal Hollow, and I've got some maps because they make everything easier to understand. Okay. Coal Hollow is a surface coal mine located down in Kane County, a little bit close to Bryce Canyon. This map right here is a map of their permit. That orange line is the coal recovery boundary. And if it kind of looks like the state of Texas a little bit, there's that 90-degree angle, or the 90-degree corner on the left side with the orange line on the top. That's kind of where we're going to be talking about. So it is a part private surface, part federal coal mine, and because of that was required to get federal mine plan approval. Last year, originally, I wonder if I can, I do. Okay, originally, the mine plan called for them to mine this area here. And then in 2022, they submitted an amendment to the plan to come in and mine this area here. We call these D1. So this map is a map of the coal recovery sequence. And so last year in April, they were finishing off, they had completed all of this mining. They were finishing off this pit F7 and F8. And then at that point, they were going to come over and mine D1 from left to right. I don't know if you can see on the map, there is a stream that comes down right here, and it comes right down through pit D1. And because of that stream, they had to, in order to mine pit D1, they had to do some hydrology work. Let's see if I can get this. And what their plan called for was before they could come over and mine this pit D1, They needed to put a plug in the stream at plug A, so that any water coming down that stream would be diverted down into the pit. They needed to put another plug over here at plug B, so that, I don't recall what plug B did, but I know it was important. But that basically would stop any water from being present in this stream when they were mining through that D1 area. When they were doing the mining, although the mine plan called for them to finish this pit F7 and F8 and then come over from the west side and do D1 from this side and then that side, what actually happened was they went beyond that coal recovery boundary that was unpermitted, or it was not approved to mine. So this orange line is where they should have stopped the coal recovery, and instead they continued to recover coal throughout this green part. And if you can see this little area right here, they extended into that pit D1, and they completed that mining before any of that hydrology work was done. So the diversions had not taken place, and they were mining from the wrong direction. In April, there was a slide that happened right in this area right here, and the high wall failed, and the high wall made the because the high wall failed, it failed all along this boundary right here. And the disturbance then went beyond the permit boundary because the land came down beyond what the permit boundary was. And then it also failed along this area here. When the division went and inspected, they issued, they discovered when they inspected the high wall failure that they were mining outside the approved boundary. And they issued several violations. The first thing they issued was a cessation order to stop all mining in pit D1, and on the basis that there was not adequate bond, since they were not operating in the approved mine plan, it was not bonded for what they were doing. They also issued 3 NOVs, and those are the CH 041222023-1, -2, and -3. NOV 2023-1, that matter was related to a road that they were doing maintenance on, and they went beyond the boundaries of the road. The parties agreed, Alton Coal had an agreement with the county or the city to actually maintain that road. So the division agreed to just vacate that NOV. That was not a violation. NOV-2, that dealt with the failure to follow the engineering standards in the mine plan that resulted in the high wall failure and the excursion past the permit boundary where that high wall failure took place. And then there was the NOV-3, which dealt with the failure to follow the hydrology plan to complete those plugs to divert that stream before they actually were mining in the D1 pit. So the division filed or issued those NOVs. Alton Coal filed a request for review by the board of the cessation order, NOV-2 and NOV-3. And those the board assigned to Chris Hansen, the hearing examiner. We ultimately were able to negotiate and reach a settlement of all of these and have agreed that the division is going to take certain steps and modify some of the NOVs, and in exchange, Alton Coal is going to drop their request to review these NOVs. So there was a stipulation signed, and on the stipulation, there were, let's see if I can find them. there were some modified NOVs, and the summary of the settlement is basically, first, that the division has agreed to vacate the cessation order that dealt with the bonding and modify NOV 2 and NOV 3 to add the failure to be appropriately bonded for what they were doing to NOV 2, which dealt with the engineering, failure to follow the engineering. So the bonding has been added to that NOV. And then NOV 3 was, again, the hydrology NOV, that they failed to follow the hydrology plan. And based on these modifications, the parties have agreed that this is just the 2 violations that can continue on the record. Are there any questions that I can answer?
Board, any questions? I've got one question. I'm just curious, the failure of the high wall, was that because it had been oversteepened? Was it excavated to a steeper angle than was geotechnically stable? Or was there another reason?
That is the division's position, that it was not an appropriate angle for the high wall, because it had been taken too far back in order to get right up against that boundary. I believe that Alton Cole also believes that it was caused by the wet weather that we had this spring. But either way, we've agreed that it was not appropriately mined for the conditions and the plan.
Thank you. Any other questions for Ms. Harris? Seeing none, does that conclude your description?
That's all for me, unless, do you have anything to add? All right, that's all for me, thank you.
Mr. Begley, over to you.
Chairman Borden, with your permission and indulgence, I would like to also introduce you to my co-counsel for this matter. This is Emily McKay. She's our new O'Hara Fellow that will be working with the DNR, entire agencies. She has a aptitude and a preference and an intrigue for water, all things water, but she's also really willing and able to roll up her sleeves and get to the bottom of any and all help that DNR needs and all the agencies within it. So with that, I would like to introduce you to Emily, and hopefully you can say hi after this.
Welcome.
With representing Mr. Hansen on this, I just have a couple things to add. Mr. Hansen's really apologizes for not being able to be here in person. He had a personal conflict that really prevented him from being here today. So based on his professionalism, as always, he insisted that we get together, and I am going to be basically reading a script that he wanted me to say with a couple of little add-ons. First and foremost, with him not being here, I can say that based on his reputation and professionalism, both the operator, Alton, and the division both suggested and recommended Mr. Hansen to be the hearing examiner in this matter. And as the board knows, he was delegated with that authority initially. And Mr. Hansen, because he would like to cure any regulatory issue and make sure that the mine becomes operational as soon as he possibly could, directed me to initially have a pre-hearing conference call with the attorneys, Mr. Allen and Ms. Harris. We did that, and I think that initially we were on the path to maybe consider if there's any other option other than to pursue the violations in the cessation order. And in so doing, we scheduled a site visit. All the attorneys and Mr. Hansen and myself visited the mine site on June 8th, 2023 to review firsthand what the situation was. And stemming from that site visit is the process that was basically put in motion, and I believe that Mr. Hansen would be very complimentary to the attorneys that were working on this. I think Liz Harris and Mr. Allen demonstrated exemplary legal work to get whatever issues that were involved at the time resolved between the parties. And Mr. Hansen is very appreciative of the fact that the path to settlement was in the control of the parties and not the board. And he is authorized me to basically compliment the attorneys, but first and foremost, let the board know that he has reviewed every aspect of this file. He's followed the settlement discussions as much as he possibly can without interfering with them, and he's reviewed the stipulation that's been put on file, and he's approved of the stipulation and has signed the order in his capacity as a hearing examiner, which I've provided to Ms. Whittier for the board's consideration.
Excuse me. In summary, Mr. Hanson recommends, he's very comfortable with the stipulation as agreed between the two parties.
Yes, Mr. Borden.
Okay. And he is also comfortable with dismissing any further requests for agency action in this matter.
Yes, Mr. Borden.
Okay. I believe if the board is comfortable, I believe it would be appropriate for us to vote that we on those issues together, unless we need to step out and discuss. I would entertain a motion.
How do we so is the motion that we approve the hearing examiner's recommendations? Okay, so make that motion.
All those in favor say aye.
Aye.
Let the record show that was unanimous, and I will also put my signature on this order. Thank you. And that brings us to item number 2, which is docket number 2023-032, cause number 139-172, in the matter of request for agency action of Petro Swiss Capital Partners, LLC, for an order requiring an accounting and payment of royalties to Petro Swiss Capital Partners, LLC, from Blue Diamond Oil Corporation for the PAL 2-13-A2K and Ute 3-35Z2K oil and gas wells, Duchesne County, Utah. This matter also had a stipulation agreed to by the parties, and it was also a request dismissing further requests for agency action. And I actually signed the order pertinent to those two issues yesterday, so I believe that concludes this item as well. Which brings us to item number 3. And while Mr. Mayo is getting set up, I will just read what item number 3 is. This is docket number 2023-036, cause number 138-04, in the matter of the request for agency action of Rewater LLC for an order waiving Utah Admin Code Rule R649-9-4.6.1 as it relates to the permit application for the proposed R&I Pleasant Valley Evaporation Ponds numbers 1 through 4 and Evaporation Basin number 2, recycled water ponds to be constructed and operated in Section 26 and the northwest quarter of Section 25, Township 4 South, Range 3 West. And I would now ask for appearance of counsel.
Thank you, Mr. Chairman, members of the board. Mitch Mayo of Lear & Lear PLLC on behalf of Rewater LLC, the petitioner in this cause.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Mr. Mayo, over to you.
Thank you, Mr. Chairman. Again, Mitch Mayo, Lear & Lear on behalf of Rewater LLC. With me today and appearing in person at this hearing are Mr. Kevin Darcy, Vice President of Business Development with Rewater, and Mr. Brett Mickelson, the President of IGES, Inc., which is a civil engineering firm contracted by Rewater. Can we please have these witnesses sworn in at this time?
Would you please raise your right hand? Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you for that. The resumes of Mr. Darcy and Mr. Mickelson were submitted as petitioners' exhibits T and W, respectively. If separately asked about the contents of their resumes, they would confirm the same as true. Mr. Darcy will be testifying as a fact witness in this matter. Mr. Mickelson, who is new to board proceedings, and I plan to qualify him as an expert in civil engineering with an emphasis on waste management facilities permitted under the Division of Waste Management and Radiation Control. Also, with the board's permission, I'll be moving for admission of my exhibits at the end of my case in chief. At the beginning of 2023, Rewater purchased the facilities at issue from Dalbo Holdings, Inc. for two purposes. One, to operate the existing evaporation facilities, disposal facilities that are located on the parcel, and two, to permit, construct, and operate produced water recycling ponds, what I'll probably call the recycled water facilities, that each exceeds the size limits for evaporation ponds outlined in Utah Administrative Code Rule R649-9-4-6.1. And I may refer to that as the pond size rule. The pond size rule, as the board may be aware, limits ponds of this nature to a size no larger than may hold 10 acre-feet of water. However, in the current operational climate in the basin, this is an insufficient amount of water to really be beneficial to continued operations. On June 5th of this year, Rewater filed a permit application for RNI Pleasant Valley Evaporation Ponds number 1 through 4 and Evaporation Basin number 2, which I will shorthand as the permit application. This permit application details Rewater's plans for development of the proposed recycled water facility. The recycled water facility is designed to accommodate the ongoing full-field development in the basin, and as such must hold more than 10 acre-feet of water to be available for single use. Because the permit application requires an exemption from the pond size rule, and given the regulatory transition underway regarding oil and gas exploration and production waste, Rewater determined that pursuing division approval of the permit application was impractical and the instant request was necessary. From the beginning of this process, Rewater has been engaged with and has informed both the Division of Oil, Gas, and Mining, the division, and the Division of Waste Management and Radiation Control, WMRC, of all relevant information related to the permit application and to this request. Both agencies have been very helpful throughout this entire process. Rewater recognizes the nuances and broader policy implications presented by this request and wishes to express formally on the record its appreciation for both the division and WMRC's efforts to educate Rewater and to learn the details surrounding Rewater's permit application and its proposed plan of operations at the recycled water facility. A couple of important items to note before we begin regarding the nuances of this request. One, the recycled water facility is not a waste disposal facility. Rather, it is a facility designed and built to manage and recycle produced water for commercial use in ongoing oil and gas operations. And two, the recycled water facility is not an evaporation pond. And the reason I bring these up is fairly apparent. First, waste disposal facilities This is not a waste disposal facility, but waste disposal facilities will, from now going forward, be regulated by a different agency than the Division of Oil, Gas, and Mining. They will be regulated by the Waste Management and Radiation Control Board. So I'd like to point out and make clear off the outset, this is not a waste disposal facility, which is why we're here. The second nuance is that this is not an evaporation pond. And the reason we bring that to your attention is the whole issue the board must decide today, whether to waive the pond size rule, applies only to evaporation ponds. So why did we bring it? There are no regulations specific for recycled water facilities. They are in the works. It's my understanding that next year at this time we will have some regulations that can fit this more squarely. But given the regulatory gap and the anticipated length of time before completion of that rulemaking, ReWater determined, again following consultation with both agencies, that the evaporation pond rules are the closest regulatory analog and should be followed where applicable. Thus, ReWater is here today simply to request the board do three interrelated things. One, waive the pond size rule as it relates to the permit application. Essentially allow the division to review the application regardless of the size of the ponds being requested. Two, expressly allow the division to waive the pond size rule as it relates to a future planned fifth basin. Essentially, ReWater is planning for this facility to put in additional basins, but isn't going to do them in this batch. And knowing that the rulemaking may take a while to get in place, ReWater wants to avoid having to come before this board and make this same case a second time. And the third action item today is simply to do what the division stands ready and willing to do, and that's order the division to review this permit application as timely as possible. This, again, has been pending since June 5th, and the construction season is nearing an end, and that's why that request is included. The changes requested today represent a reasonable and common sense approach to environmental stewardship, and they are necessary to accommodate burgeoning oil field development. Recognizing this, on August 9th, the division filed a response and notice of non-opposition in this cause, wherein the division states its support for the request as pleaded, pending satisfactory proof at this hearing. Of note, the division made clear that it is both comfortable with the approach being taken and with regulating facilities like the recycled water facility at issue here today. The board has jurisdiction over this cause pursuant to Utah Code 40-6-5, particularly subsections 1 and 3. I would like to note, however, that the board does not have jurisdiction over WMRC. WMRC was included as a party in this action solely as a professional courtesy and to ensure that they both received full notice of the proceedings and an easy opportunity to participate herein if they chose to do so. But nothing in this cause should be read as conveying that authority to the board to regulate WMRC. Notice was provided as required under Utah law to all interest owners and to all relevant governmental agencies as required under the regulations. They were sent to their last known addresses of record in the office of the Duchesne County Recorder. In addition, notice was published in the Uinta Basin Standard, the Deseret News, and the Salt Lake Tribune during the first week of August 2023. Finally, as has been discussed here, notice was provided to WMRC and to their counsel, Mr. Brett Randall, Assistant Attorney General for the Environment and Health Division. WMRC, as I mentioned, was included as a professional courtesy and to allow them the opportunity to both review and opine as necessary. Aside from the aforementioned response from the division, there have been no other comment letters or responses filed in this action. Based on that, it seems not a large leap to assume that the parties noticed implicitly approve of the request here today. And with that, I'll begin my examination with Mr. Darcy.
Mr. Mayo, one thing I realized I did not do is I did not ask the division, especially regarding the expert witness. Do you have any concerns about us recognizing the one witness as an expert witness?
I'm happy to voir dire and give kind of a background on his education and experience when he comes up, if it makes the division more comfortable.
If that's when you want to do it, we can do it there.
Yeah, I was just waiting for all that before we make a comment. Thank you.
Okay, we
Perfect.
can wait till it flows better with what you prepared.
Thank you. I appreciate that reminder. Okay, Mr. Darcy, Would you please state and spell your last name and state your business address for the record?
Yeah, Kevin Darcy, Kevin Darcy, Darcy. Business address is 3319 North University Ave, Suite 200, Provo, Utah, 84604.
Okay. And what is your current position with Rewater?
I'm the Vice President of Business Development.
And do you have access to the corporate records in that role?
Yes, sir.
Quickly, could you mention the corporate and bonding status of Rewater LLC? Is it where is it located, and is it a business in good standing?
Yeah, it is a LLC registered with Utah. It is bonded with all appropriate agencies and fully insured.
Okay. And maybe a quick side question. The facility at issue today here, the intention is it will be fully bonded as well.
Correct, yes.
Thank you. Moving on to essentially all of the testimony. Are you familiar with Exhibits B through S submitted in this cause?
Very familiar.
And were they prepared by you or someone in your offices under your direction or supervision?
By me.
Okay. Thank you. Let's start with Exhibit B. We're talking about the management recycling of produced water, so it helps maybe at the outset to define it. Please help the board understand what produced water is from Rewater's perspective.
Sure, and this is probably a very simple definition, but there's been a lot of questions through the process of different water rights, and so we laid this out that it is water that is brought to the surface in connection with oil and gas production. Brine, saltwater, flowback are synonymous with the term produced water. So it is a byproduct of oil and gas production.
And where does that produced water come from? Why does it exist?
It is in the formation, native, and it is moved up the wellbore with the oil and gas in somewhat of a mix up until it's separated on location.
Okay. So in the pore space, the same pore space where the oil and gas resources exist, there are volumes of water as well.
Correct, yes. For every barrel of oil, there's typically anywhere from 1 to 2 barrels of water that'll come to the surface.
And this is probably fairly regionally specific. You're talking Uinta Basin.
Horizontals in the Uinta Basin that we drill tend to be around that,
So for every barrel of oil you pull out 1.5, 2 barrels of water.
more or less.
Okay, that's helpful. With that background in mind, maybe it's probably good if you can just walk the board through kind of the summary of events on what, why Rewater bought the facility and what their intentions are.
There was a need for frack water, kind of south of Mighton.
Okay.
And with that, there was the concept to build 2 fresh ponds and then expand the produced ponds as well. So this facility was owned by a company that specializes in evaporation in the basin and other water services. They had previously permitted this for evaporation. When we purchased the facility, we had intent to utilize those permits to store more produced water and expand the facility. And just with the regulation changes, those permits had lapsed. And so we've taken that permit package and resubmitted that.
So the division has approved these same ponds essentially, and maybe at different sizes or slightly different locations previously?
More or less the same exact locations. As regulations changed over the years, the permit was adjusted to stay with the regulations, but these were initially proposed, 14 or so years ago, and then renewed, updated as the regulations changed or improved.
Okay, and you mentioned, we're looking now at a map, you mentioned there was need for water south of Mighton. It looks like, am I wrong, that's the north boundary of the GMBU, or at least approximately. is roughly south of the location here we're talking about?
Yeah, it is immediately adjacent to that 120,000 acre federal unit.
A water flood enhanced recovery.
Correct.
Significant volumes of water are probably needed to operate a unit like that.
Correct. Yeah, I think they dispose of 30,000 barrels a day roughly at the moment, with capacity up to 50,000 barrels a day for that water flood.
Okay. And this is actually helpful, so you can see that, to clarify for the board, the ponds in light purple at the top that they see, those are the ponds you're requesting here today. But the ponds at the bottom, those are currently operational. Is that right?
Correct. The southwest, you have existing evap pond number 10 that is fully functional. We have drawn about 500,000 barrels out of that for 2 recent pads that were fracked. And then the 2 ponds to the right are for holding fresh water. They're about 600,000 barrels per pond. And for context, we are currently fracking with about 700,000 barrels per horizontal well.
Okay. And that 600 is per pond, you said?
Per pond, correct.
And to clarify, the evap basin, evap pond in that southwest corner, that is a disposal facility.
It is a commercial disposal facility. Several operators will drop off their water instead of going to an SWD. It's another option.
So would it be fair to say that, and this is a guess here, that's been regulated historically by the Division of Oil, Gas, and Mining, but likely will transition to WMRC management regulation
If
it maintains as a disposal facility?
If it maintains as a disposal facility, we view that currently how it's operating as a recycle reuse, however that is defined. That water is coming out of the formation and then going back into a completions job. So it is kind of reliving back where it came from, more or less.
Okay. And so just to clarify for the board, essentially, Rewater's asking them to approve the pond size rule waiver for those 5 ponds at the top. There was a secondary request about allowing the division to waive the pond size rule in the future for a later. Is that the pond just above the southwest evaporation pond there?
Correct. And we call that the Fingers Pond. It was a very unique design years and years ago, and its primary focus was for evaporation. So it's deeper, like any standard pool would be at one end, and at the other shallower. And so the idea is, and there's somewhat little mounds going through it, and so it looks somewhat like your hand. And so the concept is that as the water gets shallower on the way up, it's easier to evaporate. For us, we want to evaporate as little as possible or as feasible, because we're able to use that resource in our frac. So there's a business case for replacing that with a newer pond. Also, historical ponds have 1 liner in them, so it would be the kind of the industry standard of the double lined, a little bit cleaner, safer, and just location wise, it's in a very good spot. So we would like to reclaim what is there because we feel it's a little bit antiquated, and replace it with a similar proposed recycling pond.
Okay. And if the board approves the second prong of the request, allowing the division to waive the pond size rule in the future, would Rewater be comfortable if that were limited to that permission is given to the division until new rules are in place? And if new rules are in place, you just follow the new rules?
Yes, sir.
Okay. Moving on from that, kind of what's the reason you need a pond size waiver?
The current size is an order of magnitude smaller. For reference, anecdotally, we had the EPA visit the facility recently, more on just to try to understand how these facilities work. And the question was asked, why don't you just use 1,000-barrel tanks? And that's a little extreme, but for each of those fresh ponds, you would need 600 tanks thousands of tanks to get to this scale. And in this case, with the ponds, we're looking at, ballpark 34 small ponds. So just your disturbance and your depth as well, like the magnitude the amount of volume that we use in one frac is 3 of these ponds filled with water, if not 3.5. And so from a surface disturbance standpoint and just logistically too, if you had 30 ponds that you had to manage the water levels of and make sure that everything is in good shape, it just would not be feasible. The cost of the liner alone for that size is, outside of the construction, the surface use, it's somewhat unreasonable, and we would never actually go through with that. We would just stick with the fresh ponds.
Okay, that makes sense. And I would imagine, 5 ponds close to each other is obviously a lot easier to administer on the enforcement side for the division staff and resources.
Logistically, it's just much easier for everybody involved.
Okay. Do you have plans, and this is probably maybe a little premature, do you have plans to pipe this? Is plans to truck this? Do you have short-term, long-term? You want to talk through that?
Sure. We have a pipeline under construction that's about 6 miles coming into here with volume. We will build up a kind of a better treatment on the way in. So the facility, how it operates currently, is kind of a vaulted system, just a very standard separation. Water comes in on a truck, it's dropped into a vault. The water and oil separates, water goes through to another pond, and the same process happens again. So it's a very simple separation. And so,
And by vault, are you talking about
so
this type of stuff?
it more or less is the same, like it is the same concept of separation, which you see in the oil field on a lot of locations too, but is a much simpler version that's in place right now. But we will, for the piped water, have something similar to this gun barrel, which has cascade tanks and is just able to handle more volume and also treat to a higher spec. So we're incentivized to take as much of the residual oil off as we can because you can sell it. And then additionally, we want the product that's going in the ponds in the best condition possible because we're going to have to treat it before it goes back downhole.
Okay. We're all well aware of the water issues in Utah, so there's probably not a significant need to belabor that, but there is some concern with ponds like this, given their size, about effects on groundwater. I know you Rewater met with WMRC and division staff early on in the process, and after meeting with WMRC, did you make any modifications to the permit or any adjustments to your plans to kind of help address any concerns they expressed about groundwater monitoring?
As proposed, we do have monitoring wells, double lined. It's pretty sophisticated as designed. There's a lot of geology work that went on in the area too, core taken historically. So where this is located and with the monitoring wells that work in place, we're very comfortable. Even on our fresh ponds in this area, while building them out in one area, there was some shallow water that's just fresh water that comes to surface, and we built out what is a French drain underneath it. So from a business standpoint, we want to make sure that the integrity is there so our investment is safe, and that we're able to hold that volume. So it's designed to a pretty aggressive spec on the safety side.
Okay. And maybe just to, I guess, put the board and division's minds at ease, this isn't the last regulatory stop on this train. This is probably the first regulatory stop on this train. There will be additional agencies that will need permitting done and approvals through this process. Is that right?
Yes, and the stakeholder involvement we've had to date with all of the agencies, owners in the area, there's quite a regulatory hurdle in general, which not saying that as a critique, it's fair. But if you were to look through our permit package, it's hundreds of pages. The amount of geology work that's been done, design work from engineering firms, it's been quite a complex process. So where these are laid out with the design that's in place, these are extremely kind of well planned.
Okay. Perfect. Before we conclude with you and allow the board to just ask questions, are you familiar with the certificate of mailing that's on file in this cause?
I am, yes.
And Exhibit A that was filed, I don't have an image of, but was the returns of service of those mailings. Are you familiar with that?
I am, yes.
Okay. Who's on that list? And,
Yep,
who did
sure.
you notify?
So fortunately for this project where we're located, we have a handful of large ranch owners in the area. And so we don't have a very segregated position where we had to notify 40 people. And the same is true on the mineral position too. So this is a very unique location. If there was fee minerals underneath this and we had to notify 100 folks, it would be a lot more difficult. But we have directly under it one mineral owner with the tribe. The Ute Indian tribe also sends us, we purchase a lot of our fresh water through them, so they're currently operating on the facility. The BLM is immediately to the south of us on the mineral position. They were notified. We had some conversations with them too. The EPA was notified just because of the location within the tribal boundary. We met with them on the location as well last week and spent about 3 hours with them just walking through what it was, what we're seeing, how we're planning this. The county of Duchesne and then those ranchers and regulatory agencies that were appropriate. So we've had quite extensive stakeholder involvement in this process.
Okay. Perfect. I don't have any further questions for you. Turn the time over to the division.
Division, any questions for this witness?
Just a clarification. Could you explain to me what is the difference between a pond and a basin? I know you have full ponds on your request. What is the basin?
In this scenario, the basin is the furthest, south isn't the right word, but the height. So pond 1 is, with the way that the cascade of the ponds is designed, your pond 1 is the furthest from the ground. It cascades down, so you always have an area for the water to move to, and your evap basin 2 in this case is your final settling. And so when designed for evaporation, there would be some kind of similar to the concept of separation. As you get further down the line, typically you would try to have maybe your lesser quality fluids ending up in your final basin.
Okay, thank you.
So there's not a technical difference necessarily between a pond and a basin for division perspective.
For how they will be built and designed, no. We would view the ponds will be built to the same spec. They will have the exact same monitoring, more within reason. That will just be the last, most shallow of the 5 or 6 ponds.
Okay.
With the board's permission, the division staff have. What? Okay.
So on your ponds, I know we went out and looked at it a while back, but I was just wondering. Oh, Orland with the division, sorry about that. And I am the permitting manager for the Division of Oil, Gas, and Mining. Anyway, went out there. These ponds will be connected in a tier as proposed as we went out there, okay? That's the question I had, just wanted to clarify.
Yeah, and there's some minor design changes that will have to get approved by Orlin and his group, very small. But as we build out those facilities so that there is kind of an overflow. So if you're looking at the map with Fresh Ponds, or Fresh West Pond 1, Fresh East Pond 2, granted, because there's fresh ponds, there's a little bit more leeway there, but we have a connection going from one to the other. And typically, when we're moving fluid from one pond to the next, we'll always have a kind of an HDPE pumping system so we can manage volumes. The way that we're designing it up in kind of the backyard or the north side is that every time that we build a pond, that there's overflow if needed, so that we can always kind of keep a margin of safety in the next pond down. So our game plan is to build 2 of them before winter. And then as we come back to build the other 3, that it's one, more or less one giant connected facility, so that you always have kind of a safety if needed.
And I just want to clarify, because I think this has been updated now, but the ponds and the basins are recycling ponds, recycling basins, correct?
Correct, yeah. The names that were placed in the permit are from the legacy permit, so we intend to use as much of this as possible. Inevitably, you'll have some evaporation. There was also the conversation, if oil goes to 30 and there's no drilling activity in the area, these more, at that point, have to become an evaporation because you can't pull down for frack. And so the volumes that this facility can handle while fracking is pretty massive. A 3-well pad is about 2.1 to 2.2 million barrels. We're hoping when this facility is totally spec'd out that we're dealing with, maybe 2.5 million total capacity. And so we could draw that down in a 25 to 30 day window. But our intent is to try to evaporate as little as possible while we're in development mode.
Thank you. No further questions.
Board, any questions for this witness?
Sure.
Go ahead.
So just as a matter of curiosity, when you dump the produced water into your vaults and you talk about separating the oil off from the water, is there a pour point problem with that separated oil? Is there paraffin in it? Do you have to heat it? How do you handle that?
In the initial vault, with the heat that's coming off of the water itself, coming directly from the wellhead, we haven't had any issues. They skim the vault for that oil very actively. Somewhat like a hydrovac type truck will go in there, and that oil then goes to sales. The second holding pond does have a product that we think that you could create a slop oil type facility there to treat more of it. But if you were to look at the second pond right now, which is a netted holding, there is probably 3 inches of what looks like a wax that in the summer is really easy to kind of heat and get out of there. In the winter, it is solid. So there is an issue with it, and that's part of our dream scenario, is to get away from that technology and have everything in a gun barrel, and we do plan to replace that soon if we can get everything going here.
Thank you.
Any other questions? Mr. Walker?
Okay, on Exhibit H here, could you tell me where US 40 is?
So if you were to go from the rewater facility up maybe 3 miles there, it might be hard for you guys to see, but
Okay,
sections.
so it's up in that vegetated area.
Yeah, it follows.
So this is not on US 40 then? This is
No.
way south.
Further south. So if on this map, on the left side of the page, right in the middle of that map, you can see 2 ponds, which There's a third now next to Section 10. That would be Ovintiv's office. If you were to go up 2-3 miles, you're in the town of Mighton. And so that highway does run through that vegetation kind of over towards Mighton in the top right of that picture.
Got it. All right. On the diagram on the right, what's the cross-hatched area? I can't read that.
It just states inventory yard. We actually will.
Okay, so nothing to do with you.
It's for this. No, it's just within our facility. It was more just plans that we had for the area. As originally proposed, they had a landfill that was approved. It was never utilized. We're going to build probably an 8-acre pad to drill into the GMBU unit there soon, which I'll be poking Orlin and Corey about at some point.
Okay, thank you. Okay, on your ones that are in purple, what's your aerial extent as far as acreage on those
The
ponds?
so they're about 6 acres
Okay.
to 8 acres. So the entire facility is about 200 acres of land.
Okay. And the depth of your ponds here?
Anywhere from 12 to 14 feet.
Okay. And so your gun barrel currently isn't heated, and you're thinking about in the future having a heated facility?
Yeah, we're building it in the next 2 months with the pipeline coming in. So the current offload could probably handle 15,000 barrels. A gun barrel like that can handle 20. And so, our dream development scenario is we build 2 of those and then decommission the old holding pond
Sure.
because it's more effective.
And when you're all done with this, how many monitoring wells will you have around your facility?
Right now, we have, I'd say, close to, on the 2 existing ponds that are in place, I'd say that we have about 9 currently. With the design, probably adding 2 to 3 per pond, just with how it's laid out total. And so we try to have complete coverage. If we're just to drill 1 pond, we'd have 4. 2 ponds right beside each other, you'd have 6. And so you always, if you look at a pond isolated, you'll always have 4 kind of covering your boundaries.
Okay, so you're probably going to add something like 10 more?
Yep.
Okay. Oh, yeah. And can you go back to H again? Now, by comparison, your footprint down there in the bottom left-hand corner is actually smaller than the pivots that are up there. Is that accurate? Okay. Okay. Thank you.
Any
Yeah.
other?
I'd say so. I'd say a larger full pivot is probably comparable to the size of the facility.
Okay, thanks.
Any other questions? Okay.
How deep are those monitor wells going to be?
Typically, they're 1 to 2 feet underneath the liner.
Okay. And that takes care of all the potential potable water or anything that you're not going to disturb any aquifers. I assume that's what you're worried about.
Mostly trying to understand that if there is any kind of a leak, that we can catch it immediately. The way that those systems work is they're really a pipe network underneath the ponds themselves. It's a very simple, they're angled too. So the depth changes depending on where it starts and where it ends up so that the fluid will move to them. So you can look inside very quickly with the flashlight and see if there's any water that's moved over there. And so really the concept is if you have any breach for whatever reason, that you can catch it kind of day of. And so we check those things. We also have a business case where we don't want to lose the fluid just because of the cost we pay for water.
So how's the water getting to this facility? Is it being trucked from various wells? I assume this isn't being done just for the Greater Monument Butte. It's a commercial facility.
It is a commercial facility, so we take water from Berry in and around Antelope Creek, that's close to us there. We take water from Ovintiv. Scout will send us water at times too when they're bringing on wells, and the massive pop in volume when you're bringing on a well that's, say, 2,000 barrels of fluid per well or water might overrun the takeaway that they have to get into their own network. And so we'll take it until it gets to the point that they can tie in. We're looking to do more in the area too, with some of the local operators like the Ovintivs, and then take our own or water from the WEM entities down the road.
And so these companies are paying to put their recycled water there and then to take it out again. There are fees in and out, I assume.
There are, yeah. There is a standard disposal fee that's pretty average in the area, if not less than what it would cost to send it to an SWD.
And you're taking this, I assume, from multiple wells, so you've got multiple mineral and surface owners involved. It's not just all tribal, or it's going to be some fee and...
Yeah, and the product that we take as a waste product, or there's a transfer of ownership at that point, no different than if it was an SWD. You're just getting rid of a quote-unquote waste at that point.
Okay.
And so there is no... similar to if you were to sell oil at the wellhead, there's a transfer that takes place.
Okay.
But instead of a revenue, it's a expense.
Okay, thank you.
Yes, Mr. Moon.
So using produced water for frac, what does it take besides that initial separation of the crude? What else do you have to do to it to make it frac water?
So we're dipping our toes in the water a little bit on how much volume that we can use at the moment. So anywhere from 10 to 15% of our frac water at the moment is produced. We have a system of about 4 or 5 kind of standard laydown tanks that you would see. We drop in a biocide in there to pre-treat. It kind of gets shaken up, and then it is blended with the fresh water and goes to the location. And then typically frac will pre-treat water to a certain spec, and so they test it on the way in. But mostly it's just a biocide at the moment. And so for our first frac, some of the water had been sitting in that pond for years, because with these facilities, when they are just evap ponds, you're very limited in what you can take in. So if it's a 500,000 barrel pond and you think you can evaporate 50 of that over the course of a year, you can't bring in volume. So we pulled down 250,000 barrels, which is more than half of what that pond had. So we over-treated on the first round. Then we're taking a lot of really good flowback water from, say, an XCL or people in the area that, with newer horizontals, the life cycle of the water we're getting is in very good shape. It's sent down there for frac, and we're getting the first, 60, 70,000 barrels back up that had recently been treated. So overall, it's been going very smoothly so far.
So you always have to mix it with fresh water to kind of meet their spec, or eventually can you get to be able to use 100% produced water for a frac?
We would like to, but the biggest difficulty is the volume component. Like for us, if you were to look at the facility having, let's say we bring in 10,000 barrels a day, 2,000 of those barrels for a full year would be enough for one well. And so for any frac that we have going at the moment, we are constantly backfilling our fresh with 100,000 barrels a day of fresh coming in. And ballpark, we're going downhole with 120,000 barrels a day. And so we would like to use as much as possible. The more folks we have piping into the facility, the more attainable that becomes. And that's part of asking for these additional ponds too, is outside of your winter time, just having more volume on deck for your fracs, you can use more produced, because we can't pull in fresh water. If we're able to pull it in at 100,000 barrels a day and we're limited at 10,000 or 15,000 for produced, you could do it, but you could frac one well every 4 to 6 months. And so XCL is up around 60% produced water, and they've got a beautiful system that they have up there. All of their wells are piped back to that facility, and they're able to use a massive amount of it. So I think they've kind of led the basin in a lot of ways too with their technical team. But having it all on pipe, like that's where we aspire to get to.
So it's not necessarily it's just a capacity problem. Really, you could use 100% produced water for a frac and just treat it some. And
in theory, we think you could get up to a much higher number. We know that the upper limit right now that works is 60% because the XCL guys have done it. So if we had the volume, we could increase it, but we also want to kind of, work our way into it so that we don't see any issues on the backside with H2S. And that is the scary part. If you don't treat to a certain spec, when you bring on these wells, you have a lot of chemical treatment. And so some areas of the basin, H2S is native or natural. And so we're just trying to work our way up where we have good data behind what we're doing to say 20% worked, 30% worked, 40% worked. And ideally, as we have more capacity, we'll get to that point.
thank you.
Any other questions? Yes, Mr. Galecki.
Mine revolved a little bit about the regulatory. Did you say, so first on the map, on Exhibit H, where it says rewater in the lower left hand of the map, is that where the facility is located?
Correct.
Okay. And you mentioned all the stakeholders and such. Did you say it's on fee land?
Yes, sir.
But that you're surrounded by, BLM, tribal lands, everything around it. Do you have is it a zero discharge facility? Meaning, okay, what happens if you have too much water? What happens?
So there's two components. We'll build, we're in the process of building a pipeline into that GMBU unit so that if we ever run out of capacity, we could send into the water flood where it'll get utilized. Currently, if we ran out of capacity, we would stop taking disposal, and those producers would have to send the water to another facility.
So the size of the ponds, who are you regulated by?
That's a fair question. I think lots of people, to be not to put too blunt of a point on it, there will be a handful of agencies that will take a hard look at this and issue permits related to their specific area of expertise. I think what's before you today is kind of the foundational question of which agency is going to take the role of approving the construction and build out of this facility. And the second witness will talk a little bit about kind of how this meets or exceeds the requirements of not only this facility, but if it were to be considered a waste disposal facility, that it would meet or exceed those. So the short answer is I think the division's going to take the laboring oar on regulating, but there will be lots of state agencies that will probably weigh in and require a permit or some oversight of some kind.
You said you're going, potentially sell water to commercially, you're going to sell to other oil companies for fracking. I guess, isn't that a water rights issue? Was water rights consulted?
In the background, the UPA has been dealing with the state engineer. That was a question that came up. At the moment, it seems settled or on the way to being settled. There was chatter that it could be used for beneficial use. And what we had said at that point was there's no way that we're treating this to a spec that it could be used for anything other than going down hole fracking with. Some of the water that is reused, you'll see, like a town of Heber or a municipality that treats sewage water. A lot of the regulations in the mid-90s were built around that. And the water is treated to a spec where it could be used for farming alfalfa. And so at that point, there does need to be a water right. And where things have settled at the moment with the state engineer and the UPA and folks is if you were to send this down in SWD or send it into an evaporation pond, there wouldn't be. And where they're leaning towards at the moment is that the same will be true for this. The water has one opportunity. It's either disposed of or going back to where it came from. And so for that reason, it's not something that we anticipate being an issue.
And so are they incised ponds or is there embankments?
So the facility itself
Yeah,
has,
so each pond and reservoir, each unit that's holding water, are they incised or do they have an embankment?
they are partially built into cut and then partially embankment up, depending on where it is exactly. And so typically all of these will meet kind of a small dam design. And so there's a certain amount of water that can be above the natural surface. And so usually at most you're a couple of foot on your embankment.
Maybe last question. So is it a MSHA inspected site?
I don't know the answer to that.
I don't believe it would be, but I haven't looked at the issue specifically. I can't see mine safety being involved. In my prior experience on the XCL pond, I remember that they did speak with the dam safety folks, and they essentially didn't have concerns, didn't weigh in, and weren't one of the agencies that chose to regulate or get involved.
So if there is hypothetically, if there's a catastrophic breach of the facility, it goes onto federal lands, and then it will be dealt with by the feds and not the state.
Could you walk me through the acronym you referenced? I don't have context originally. Sorry.
So let's say there's
MSHA? No, I sorry. Okay, mine safety and health. The way the facility is actually set up, the fluid, if we had a catastrophic event, would move towards the northeast, and it would be on on fee. The federal being to the south, just strictly with how the slope is. But assuming if we had any issues like that, those agencies would be very involved just with the proximity.
Thank you.
And then it's my turn.
You always get the last word. Let me just clarify, is this facility on fee or tribal or fed, the surface?
The fee surface,
Fee surface? Do you know who the surface owner is?
Rewater LLC.
So you bought the surface?
We bought the facility owned the surface.
Okay,
They were one and the same.
thank you.
I just have a couple of questions on containment and monitoring systems, and you can tell me if this is better answered by your next witness. You talk about a double-lined liner containment system. Is that HDPE liners?
Yeah, I can speak to that. So the bare, on freshwater, for an example, the bare minimum is a 40 mil liner. For both of our ponds down there, we have 60 mil on that side. Historically, a lot of evaporation ponds with the older generation of rule are 160 mil liner. Some folks have depending on the dirt underneath, a geomesh just to protect the liner itself. For our plans, we will have a double line system, which will be a 60 mil and a 40 mil HDPE directly over the top and a geomesh underneath. And then your monitoring system built underneath the ponds themselves.
So there's not going to be a pressure relief or monitoring layer between the two liners?
No, sir.
Okay. That brings me to the next question. We talked about earlier about monitoring wells, but it sounds like it's more like a leak detection system, which is laid underneath the lower liner. Is that a better characterization maybe than a monitoring well, which gets down to groundwater?
Yes.
And,
Yeah, leak detection.
okay.
We would be using them interchangeably on our side, but you're viewing those as different.
Yeah,
Yeah.
in my background, I always heard those talked about a little differently. So they're basically perforated pipe placed under the lower liner.
Yeah.
And you're depending on the soil to have a low enough permeability to perch any leaking water so it would get into the pipe.
Correct. With typically there's with what we did with the French drain type setup, you've got a somewhat of a HDPE underneath with rocks in the area and then some kind of a soil so that you're encouraging the water into that pipe at an angle back to your sampling area.
Do you have a design spec for that lower soil layer that needs to perch the water, like 10 to the minus 5 centimeters per second hydraulic conductivity or compaction? Or this again may be a better question for the engineer, but
Yeah, not a great. I won't have the answer for that. I know it's to spec for what the classic evap type companies have used, so we're mimicking that.
okay.
Well, and just to clarify, Chairman, for the board is not approving the permit today, right? For curiosity's sake, obviously very important, but the board is simply saying it's okay for the division to approve a pond bigger than 10 acre feet, and the division will do all that deep dive and probably already has on some of that. So to the extent we give unsatisfying answers today, hopefully the board can rest assured that someone who knows will look at it and make that hard decision.
It's somewhere within that 160-page permit application that I don't have a great handle on personally. It's been like the amount of detail on all of this has been incredibly complicated, and we outsource to experts on most of this in the planning and implementation stage.
Okay. And thank you, Mr. Mayo. That is a good reminder that we are merely being asked to allow waiving the pond size rule, basically. Is that correct? Huh?
That's right.
Okay. Huh? Any last questions? If not, back to you. Huh?
Thank you. With that, I'm done with Mr. Darcy, and I'll call my next witness. I'll have him stand by in case there's any follow-up questions that kind of touch on the project as a whole.
Thank you.
I'd like to call Mr. Brett Mickelson. And I apologize, I've watched you all squint trying to see this screen. This next exhibit is going to be the worst of all of them, and I'd like to apologize in advance. Mr. Mickelson, I'm going to turn that on. Could you please state your name and spell your last name and state the business address
Okay.
for the record?
My name's Brett Mickelson, Brett, last name Mickelson. Business address is 2702 South, 1030 West, Suite 10, South Salt Lake City.
Okay. And who do you work for? What do you do for a living?
So I'm an evil consultant. So, I've been with IGS, actually, was one of the founding partners with IGES over 25 years ago.
Okay. And talk a little bit about your education. Part of what we have to do here is qualify you as an expert. And so I want to talk through kind of your educational experience, where you went to school, where you've worked since then, and specifically your expertise as it relates to waste management.
As you can see on my submittal, I'm a product of Utah State University, got a civil engineering degree out of there. Was immediately hired by an international consulting firm at the time called Dames and Moore, which has since been bought by URS, which was bought by AECom in the process. So I spent about 11 years there. Then several of us out of that company started IGES, and IGES is primarily a geotechnical firm. Somehow I got pigeonholed in the waste management niche of this, and I've worked in various aspects of solid waste, RECRA, CERCLA, some mining wastes as well.
Okay. And so in your professional experience, do you work with the Waste Management Radiation Control Board and their regulations and rules related to waste disposal fairly regularly?
So for clarification, I don't work with the board.
I apologize.
I've worked with staff over at the solid waste group under their various names for 35 years. And as I relate to the
push that button again, would you?
Oh, there we go. Sorry about that. And as it relates to the board, I don't work with the board. I'm currently the chair of the Waste Management and Radiation Control Board in a volunteer position.
Okay. Thank you for that. I'd like to turn it over to the division for any additional questions or voir dire.
Division, any concerns or questions? For this witness?
No concerns, a very impressive resume. Thank you.
Thank you. I'd like to request that Mr. Mickelson be admitted as an expert in civil engineering with an emphasis on waste management.
So admitted.
Okay. Thank you. Now we'll stop looking at this small slide and just speak generally. Mr. Mickelson, you heard, and it's probably best if you just leave that on because I forget to click it every time.
Okay.
You heard the testimony here today. Obviously, you reviewed the permit application prior to filing the request for agency action. Maybe just to back up, what is your involvement in this project? How did you get involved in this project?
So my involvement in this, I was not the engineer of record for the preparation of the documents or technical expert, I should say. I know of the company Geostrata and of the person that did prepare the package, and it looks to be very complete. So my involvement in this was not specifically for that package. I was asked by your firm to sort of compare and contrast the waste management regulations with the DOGM regulations at a high level.
Okay. And in your work with the Waste Management Radiation Control Board and your work reviewing this, would you say you're fairly familiar with the regulations governing waste management?
Yes.
Okay. I'll cut to the chase. In your experience, do you believe that the Division of Oil, Gas, and Mining is an appropriate, or maybe the appropriate agency to be permitting approval of a facility of this type?
It's pretty obvious from the previous approvals, the other ponds in the area, and the way your regulations are set up to deal with liquids, rather than the waste management rules that are set up to deal with specifically solid wastes of a variety of types.
Okay. And in that event, maybe following up, Chairman Borden asked a question of the last witness about the liners that'll be involved. The evaporation pond rules in the Division of Oil, Gas, and Mining's rules, the Board of Oil, Gas, and Mining's rules, I should say, they have very specific detailed requirements for kind of the construction of this type of pond. Are there any similar rules in the waste management, or is it kind of determined on a case-by-case basis?
No, they're both prescriptive, and the DOGM rules have, provisions within that for a leak detection, which is something that does not appear in the solid waste rules at all. Solid waste rules will have a primary liner of 60 mil. Typically, it's an HDPE. They also, the default is 2 feet of 1 × 10⁻⁷ material, which is going to be a clay. I've done that exactly once with a soil, and everyone else in the industry uses a GCL, which is a geosynthetic clay liner. It's a bentonite between woven geofabrics. So that 2 feet of clay comes out of the Subtitle D rules from the EPA.
Okay. Maybe just to hit on the rules applicable here today, the Board of Oil, Gas, and Mining's rules and the requirements for the pond design. In your professional assessment, are those best available technologies, or at least sufficient available technologies to ensure the security of what's happening here today?
I think the key point of that is the leak detection that's not available in the solid waste rules. So that were there to be a leak, that it is detected the way I read the regs in an actual sump that's located outside of the pond. So it's a very clear indicator of leaks. And you wouldn't have that in the solid waste side of the house. Their compliance is limited to monitoring wells, which are something completely different than the leak detection. So a monitor well in the solid waste regulations, by default, you have to have 1 upgradient well and 2 downgradient wells. But these wells have to extend down to the whatever groundwater's in the area. So for any leak detection there, you have to wait for a leak to happen, for it to get into to the ground, and for it to travel laterally from wherever the waste is being disposed of in the cell out to a well. So that time of travel of that constituent could be a very long time, rather than something that's immediately under the liner that reports to a sump that's a visible indicator.
Okay. So in some senses, because the oil, gas, and mining rules have been designed to deal with liquids, the oil, gas, and mining rules are maybe the more appropriate, if not the more appropriate rules to apply to a facility like this at the time being.
It appears to be the case, in my opinion, yes.
Okay. With that, I don't have any further questions, and I'd subject Mr. Mickelson to questions from the division or board.
Division?
We have no questions at this time.
Board, any questions for this witness?
I just
Yes,
have
Mr. Walker.
one question, Mr. Mickelson. On the monitoring wells, what types of analytes or substances are they monitoring for, and how do they do that?
So within the solid waste rules, you'll have monitoring for metals. You'll have monitoring for just typical groundwater salts and that type of a thing. But you'll also have a list of constituents of volatiles and semi-volatiles as well. So there's a whole list of constituents that you need to monitor for.
Okay, but in this case where we're doing liquids, what are the analytes?
I don't know what the analytes specifically are for your project.
Well, and maybe to clarify, there are no requirements in the Board of Oil, Gas, and Mining for those types of facilities. So anything like that, part of the difficulty is for the last year and a half, and what I think is probably for the next year and a half, there's a regulatory gap for this type of facility. So a lot of these hard, good questions, unfortunately, there aren't satisfactory answers right now, but the rulemaking is designed to kind of take care of that, and as you can see, it's a lot more complicated. Both agencies have a vested interest and a desire and a technical staff able to regulate these types of facilities, but there's still nuance that goes into that. So I would imagine some of that will come in. The board could, craft an order how it sees fit, obviously within its jurisdictional bounds. But there just simply is no requirement at this point in time.
Okay, then of the 9 existing monitoring wells they have right now, what are they looking for?
You want to come on up here? This is probably a question for the land witness, but I think what he just said, if everyone's comfortable with me relaying it, is simply for fluid. And I think the distinction that Chairman Borden made is key. One is leak detection, essentially, in Chairman Borden's view, and one is groundwater monitoring. What is currently in place, correct me if I'm wrong, is not what Chairman Borden considers to be groundwater monitoring. It's what Chairman Borden has stated as leak detection. Is that?
And I think I've worked with a lot of these water storage facilities with HTP liners, and the leak detection system, generally, you're just looking for fluid reporting to your collection basin, and that's indicative of a leak because you're up in the vadose zone.
So you're not looking for any of those specific markers, just the water itself.
Okay, thank you.
Thank you.
Any other questions? Yes.
This is actually for the division. There are a couple of existing facilities out there that were Dalbo's. Does this project, or historically, have there been any problems with the existing ponds or the maintenance of those ponds before we go forward with new ponds?
No, I'm not aware of any structural integrity issues at the existing ponds at this facility.
So there've not been any NOVs or any problems out there?
Not for containment.
To the best of your knowledge.
Yeah, to my knowledge, not for containment of fluids at the ponds. It's really only been a one pond site.
Okay.
And it's, I mean, in the bigger scheme of things, it's one of the newer ones in the state, not necessarily the newer, even though it is approaching 2 decades old. It's one of the newer facilities.
Okay, thank you.
I have a question or two for you, Mr. Mickelson. I'm just returning to my question about permeability of the underlying geologic materials, soils, whatever you want to call them, to perch water that's leaked through the HTP liner through a torn seam or something. Are there any concerns, like if this is founded on a sandy substrate, the water's not going to report to the leak detection system? You need something that's 10 to the minus 5 centimeters per second or something to drive that, perch that water underneath the HTTP liner. Any comments on that?
Yeah, you're exactly right. So part of that is if this is over fractured bedrock, for instance, you would never see that, or if it's over gravel, you would not see that report. What you need is a subgrade that has sufficient permeability that causes the water to mound up, and even if it's not just the water mounding up, just enough surface tension to fill in the voids to cause water to flow laterally, and that's also why these under drains are sloped.
Okay, and do you see any benefit to having a composite monitoring system with some small number of monitoring wells down gradient to make sure nothing's escaping the leak detection system? And are there such wells, any existing wells like that at the facility now?
I don't know the answer, but I'm happy to call Mr. Darcy back up. Do you know if there are any groundwater monitoring wells currently in the facility, or is it just the leak detection?
There's a freshwater well at the facility.
Okay. So there is a freshwater well on the facility, so a well drilled down to freshwater depths, but there is not a groundwater monitoring well. It doesn't sound like. If there is, we can update later.
What's the depth of that freshwater well? And does it produce?
Very minimum, 160 foot. We're still in the testing phase to understand if that water's usable.
So for the record, just to clarify, so the court reporter could hear it, 160 foot was the depth. It produces so-so, and they're still testing to see if it's useful, potable.
Can we? That didn't answer your question. Your question was, could a monitor well network be useful in this situation, depending on what the soil or bedrock underlying the facility? They may be useful, but they also, depending on the time of travel, may not be relevant in a time frame like the underdrain would be.
Yes, I'm flying a little blind there because I don't know how thick the vadose zone is or the nature of the underlying geologic materials. So, are they aquitards or aquifers?
I would have to look back on that. It seems like it's all shale underneath the site, but I would have to look back, so I don't know right off the top of my head.
Do you have your Exhibit L?
I do have it. I
You,
would
you have some proposed monitoring wells on that, do you not? Yeah, those red dots.
Let me see if I can zoom in here for you.
So those red dots are true monitoring wells, not a horizontal leak detection system. Huh? Is that correct? Huh? Drilled to the water table and through it. Huh?
Question for him.
You come on up here, you can just.
Yeah. Okay.
Yeah, they go back and forth. So just stay tight.
It's a bit confusing. Yeah.
When we were talking about leak detection in our permitting system, Deputy Director Bart Kittle, can he just make a comment on that?
Thank you, Mr. Chairman. First of all, I need to introduce myself, Bart Kettle, Deputy Director. I didn't do that in my previous statement. I apologize. If the board just looked at Exhibit L for the monitoring wells, but if the board looks at Exhibit Q, that lays out a little bit of detail on the leak detection system that's being proposed for this pond. And that is also laid out in Administrative Rule R649-4, specific requirements for evaporation facilities. It lays out what's required, that being a leak detection system and also a containment in the form of two liners, a primary liner that's a 60 millimeter HDP, and then a secondary liner that's a 40 millimeter HDP liner.
And do those rules talk about the minimum, permeability of the underlying soil or geologic material so that water will perch and report to the leak detection system, the horizontal perforated pipe?
Yeah, so the rules talk in general. R649, R649-3 talks about the general requirements for a disposal facility, and it doesn't. It gets into some of the siting requirements for a facility before the division considers it. There is specific permeability requirements for land farms, not for disposal facilities. The reason being is the leak detection system is between the two liners.
That's not the testimony we heard before.
Well, that is my understanding as well. The leak detection is between the two liners, so if there was some misstatements or confusions, I apologize that I missed the clarification on that.
That was my question too. It's between the liners.
It is, that's right.
Oh, well, that solves a lot of my concerns.
Yeah, sorry. I figured we were on a personal journey I was following. I apologize, I didn't.
Yeah, so the permeability of an HDP is
10 to
minus
the
ninth, right?
Yeah.
Yeah.
Okay, thanks. I'm glad we got to the bottom of that.
Thank you.
Oh, yes.
So, I don't know if this, maybe I missed it, but, we're waiving the UAC rule of 649.94.6.1. Do we have that available to see exactly what we're waiving?
I don't believe I have it pulled up. Actually, I do have it available as a slide, I think. Let me see if I can.
We may have hit it. I just, we've gone through a lot of things, but I want to make sure exactly what the order is.
9-4.
My expert brought a copy here for me to read. I've got a summation on mine, but the pond size rule, it says in total, ponds shall be designed for 10 acre-feet of water or less unless otherwise approved by the division. And so what we're asking is that you otherwise allow the division to approve a pond larger than 10 acre-feet if, when reviewing the technical information, they believe it's warranted.
And so we're increasing the size if they're 8 acre ponds and So they're not very much over 10 acre feet, is that correct?
They are fairly significantly over 10 acre feet. As I understand it, I think each one's about 50 or 60
50
acre
or 60
feet.
acre feet. Okay, okay.
So, along with it, so Ovintiv and XCL, they have large ponds. Why haven't we had to see them about this very question?
Well, I know with XCL we did in August of, or I guess September of 2021. I was here before you guys doing what I believe was the first of these types of hearings at the time. And it was a pretty involved presentation and request.
But this very question was asked and it was approved. Okay.
This was the sole request. The reason we didn't really bring that to attention is the board that was after the legislative changes that created the confusion, before we had any clarity as to where the confusion was going to get sorted out. And so the board was rightfully very cautious about limiting the precedential effect of that, and said explicitly in that order, this order is in no way precedential. So we didn't really want to focus on that and bring it up, given the board's expressed preference to kind of have each of these determined on their own. I can't speak to the Ovintiv pond at all.
Any other questions for this witness? Seeing none, back to you, Mr. Mayo.
With that, I won't belabor the point. I think it's clear today that hopefully it's clear today, there's one real central issue before the board, and that's whether they want to authorize the division to approve a permit application for a pond or a series of recycled water facilities that will hold more than 10 acre feet of water. If the board's inclined to allow the division to do that, I would suggest the other two requirements are fairly necessary and fall lockstep with those, and that being that the division have the authority to so waive that pond size rule for the future contemplated pond, and for the division to be ordered to review it in a timely fashion. And Rewater has met all the regulatory requirements here today. Notice was provided to all parties required by statute, or excuse me, by rule to be notified. And no one has appeared today. Importantly, I'd like to put the board's mind at ease. This is going to be a division-regulated facility from all the leanings that we can gather, and it meets the division's established standards. And it exceeds, in a lot of ways, WMRC's established standards for waste disposal facilities. One more key thing, Waste Management, Radiation Control, the other agency with a primary interest in a facility of this type, was fully noticed, included as a party, and given every opportunity to weigh in. And they have chosen, based on the filings and the presentation, to not do so. It's my hope that the board sees that as an acceptance of what's happening here. And with that, I'd ask the board to approve the request as pleaded.
Division, over to you.
Thank you. As Mr. Mayor stated, the reason we're here is because, to be quite honest, we don't have rules in place that specifically address recycling facilities. We have evaporation facilities, which is our closest counterpart, and that's the ones we're running with right now. The three things that Rewater is asking is, one, whether the board is okay with creating pond sizes that are this large. Two, if so, allow the division for future construction to also have the discretion to waive that size requirement. And three, to ask the division, if you approve of this, to move ahead on the permitting application process. As it stands, with the regulatory changes that are going on, we're in constant contact with WMRIC in this process. They have not indicated, just as Mr. Mayor pointed out, any objection to this. As the division has a permitting process in place for evaporation facilities that we follow as we're permitting this facility, and the current understanding is that is in the process, and we are in contact with Rewater on certain requirements there. The division has no objection to any of the requests here made, but with the understanding as we finalize our rulemaking process specifically for recycling facilities, that they will fall under those rules just as every other party that comes forth wanting to do the same thing. With that in mind, I'd like to turn some time over to Deputy Director Bart Kittle to make some comments.
Thank you. Hopefully I'll be able to clear up a few of the questions I think the board has. So as listed in the division's response of non-opposition, in 2019, the general session HB 310 amended the definition of solid waste under the Solid and Hazardous Waste Act. And that the primary implication of that amendment is it put the regulatory responsibility for solid waste from EMP sources under the Division of Waste Management and Radiation Control. I'll refer to them as WMRIC from here on. Through conversation with WMRIC, the division has agreed that the board should have continued jurisdiction over recycling facilities such as being proposed in this proposal. The catch in this is, for administrative rule, the division does have R649-9 that lays out the requirements for evaporation facilities, but it doesn't specifically lay out the requirements for permitting or operation of recycling facilities. R649, the division believes R649 is adequate for the citing and the review of this, and it addresses many of the questions the board had today related to citing, leak detection, and secondary containment for a facility. What R649 doesn't address is the requirements for recycling and the requirement to not accumulate solid waste. The division believes that we can review this permit and address those two items and conditions of approval in the permit while the rules are being developed and adopted by the board. And then the division would expect that the facility conform with the rules once they're adopted. That's it for me. If there's questions, I'll happily try to answer them.
Any questions for the division? Yes.
So as was mentioned by division, there are three things to be considered. The third item is, do you understand that the request is just being for one future pond to be approved, or is division understanding this to be all requests going forward on any ponds?
In regards to future size requirement, waiving future size requirements?
Yes.
Our understanding right now is they have one proposed. Our understanding, though, is also, before they get to that point, we will probably have rules that will be approved by the board that we will follow from that point on.
It's highly unlikely that the division will need to exercise the authority that we're asking the board to grant them relating to that future pond. We anticipate the rulemaking will be done. But we've been around enough rulemaking to know that it sometimes catches snags, especially when multiple agencies are doing it simultaneously to kind of mirror one another. So just to build in that and not have to come back before the board and present the same case again, that's the purpose. But we will absolutely, Rewater is intending to follow and be compliant with whatever new rules are promulgated once they're in place.
Any other questions?
So what happens when rules are promulgated and maybe they're drastically different? Do you just have to shut the facility in until you can comply or decide to move on?
Yeah, in the process, if there's regulatory changes that are going to affect any of these operators, they'll be made aware of these. There'll be a time period, a grace period to conform. The option is without, the way it currently stands, we will continue to regulate recycled facilities. If operators don't want to move into more of a disposal facility, go back to more of an evaporation pond and get rid of produced water that way, they will then move over under WMRIC's standards, which they will be coming up with rules for as well. So there'll be a grace period there, an opportunity to comply, and if not, they won't be left in regulatory purgatory. There'll be a way for them to continue. They'll just have to decide on their business model what they want to do.
Okay, thank you.
And maybe to just bolster that, there's it will be a functional facility either regulated by DOGM as recycling or by waste management. And to the extent I can proffer this on the record, we've been assured by Waste Management they would be comfortable issuing a permit for this as a disposal facility with the caveat in the permit that you could use it for injections. The division is comfortable permitting as a recycle facility that will eventually become waste disposal. The essence is both agencies are very comfortable with this facility and what it needs to be. It's just a question of which agency, and I think the rulemaking is going. I would be surprised if it didn't take a hard look at the couple of big ponds that have been put into place, and so I don't think there's much of a likelihood of an existential regulatory gap once this is created.
So where are we in getting new rules? Are we close to being done? Are we just starting? Where is that?
The rulemaking process should be considered near the starting point of it, in that the division has a draft that they believe the recycle rule should be, that is getting ready to be released out to stakeholders for comment. However, I think it's probably appropriate to note when we look at R649 and R649-94 specifically, the specific requirements for evaporation facility, I anticipate that those will probably be the baseline for the proposed rule for both the division. And while I can't speak for waste management and radiation control, I know they're very familiar with those rules, and I think there's a fair chance that it could be a baseline for their rulemaking as well.
Thank you.
Anybody else? I've got one quick question. I think we would all agree that it's better to recycle this water. This connate water is probably saline, really doesn't have a lot of other potential uses other than using it back for, oil production and hydrocarbon production. So I think we'd all be in agreement that this is a good thing, and that the 10-acre ponds are prohibitively small to put water to beneficial reuse like that. But could you shed any light on why the 10-acre number was originally developed?
Maybe a small amount of light, in that the division felt at the time of the rulemaking was made for a 10-acre requirement that ought to be looked at very hard. Rather, a pond size larger than that was appropriate for the size. As you get the surface size too large for ponds, two things happen. One, obviously the volume increases, so if there is a problem, it takes longer to remove the fluids from it and address that problem and fix it. And then the second thing is that if you get enough surface area in the pond, you can get wave action issues. 10 acre is a very conservative small amount, though.
Thank you.
I do have one more question.
Yes.
Sorry. Do we have a maximum size anywhere? I mean, is this just open? We waive the size requirements, but do we have a maximum size?
The permit application's already been submitted, so I think for this specific matter, if the board wants to make this order similar to the XCL order from 2021 and essentially say this has no precedential or very limited precedential effect, then I think essentially the board can take comfort in the fact that the size is limited by the existing permit application.
Okay.
The division, if the permit application were changed after this to quadruple the size of those ponds, my guess is the division would have discomfort and we'd probably be back here before you.
But that's already been submitted and they're aware of the size you want for these ponds.
That's right.
Great, thanks.
Yep.
Anything else from the board? Okay. Back to you, Mr. Mayo, and I do think we need to enter those exhibits as well.
I was going to say, I think that's about it. I believe I've already concluded, and I won't waste your time concluding a second time. But it's probably appropriate to move for admission of exhibits. I'd like to move, we didn't necessarily discuss each and every one of these today, but we flipped through them and looked at some. I'd like to move for admission of exhibits A through C, and exhibits G through T, and then exhibit W.
Sorry, let me catch up with you.
That's okay. A through C, G through T, and W.
And I have two lists of ABC exhibits. One says petitioner's exhibits attached to the RAA and the other petitioner's exhibits. Can you shed any light on that?
I can. We didn't discuss directly any of the exhibits submitted as attached to the request for agency action, but to the extent the board would like, we should probably move for admission of those exhibits as well. They are part of the record because they were included in the request for agency action itself, but it's board preference, and I'm happy to move for those admissions as well.
It's okay.
Okay.
We don't have to do that.
Perfect. So I guess move for admission of A through C, G through T, and W.
So admitted.
Okay, thank you. And with that, I'd request you approve.
Any last comments from the division?
Nope.
I think we would like to step out and just discuss very briefly. So we're going to go off the record, and we'll try to be back as soon as possible. We are back on the record. Thanks for your patience. I would entertain a motion on this.
I'd like to make a motion to approve the request for agency action as submitted.
Second.
Before I call the vote, I do want to say two things. First, this decision is based on the specifics of this case. We don't really intend it to set a broader precedential value. The second thing, I think this whole long discussion we've just had highlights the importance of the rulemaking and somewhat the urgency of the rulemaking around this, so that there is more clarity going forward. So we'd encourage the division to give some priority to this one. And now I will call for the vote. All those in favor say aye.
Aye.
Let the record show that was unanimous. We will be breaking for lunch and reconvene at 1 o'clock, unfortunately without me, but I am leaving you in the capable hands of Ms. Garrison, who will enjoy the afternoon. And will you please draft the order?
I'm happy to do so. What time would you like us back from lunch?
1 o'clock.
1 o'clock? Perfect.
If that
Thank
works. Thank you. We are off the record.
We are back on the air after lunch. We are moving the, Rich Borden, our chairman, by the way, has been called away, so I'm filling in as chairman here for the rest of the causes. We're moving to, kind of moving around to what was number 6 on the agenda. We are going to do that one first. We are doing docket number 2023-039, cause number 130-24, in the matter of the amended request for agency action of Ovintiv USA, Inc. for an order modifying and extending the board's orders entered in causes 139-90, 139-134 to 1, reorient a drilling unit from stand-up to lay-down, and reduce the heel-toe drilling unit boundary setbacks from such drilling units. 3, eliminate any upper Wasatch interwell setbacks from the Parank well, 13-10-3-3-3 WH well. Welcome, Mr. Mayo.
Thank you. Appearances of counsel, Mitch Mayo of Lear & Lear PLC on behalf of the petitioner, Ovintiv USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you.
Thank you, Madam Chair, Ms. Chairwoman. If there's a preference, please let me know. Members of the board, Mitch Mayo with Lear & Lear on behalf of Ovintiv. With me today in person is Mr. Ashley Ellison, a senior land negotiator with Ovintiv. And with us remotely by order of the board are George R. Jennings III, a geologist, and Mr. Christopher Wall, a reservoir engineer. Because the witnesses are appearing remotely, I do have my phone on in case we need to connect or have a sidebar, so please forgive me if it dings during this hearing. Could we please have these 3 witnesses sworn in at this time? Stand up. Give that right hand thing.
Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, and I didn't see, George and Christopher, can you guys hear us?
Yes.
Okay, she's going to now administer that same oath to you, so if you'll follow her instructions as well.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Okay, thank you for that. The resumes of these 3 witnesses, Messrs. Ellison, Jennings, and Wool, have been submitted collectively as petitioner's Exhibit A in this cause. If separately asked about the contents, they would confirm the same as true and correct. Mr. Ellison will be testifying as a fact witness in general land development issues today. Mr. Jennings and Mr. Wool were both recognized as experts in their respective fields in cause number 130-23 on last month's August docket. In light of Mr. Jennings and Mr. Wool's resumes, included in Exhibit A, and with presumed stipulation of counsel from the division, I would move to recognize Mr. Jennings and Mr. Wool as experts in this cause in their respective fields, in geology and reservoir engineering, respectively.
Division.
Yeah, we have no objection to that.
Also, with board's permission, and I'm assuming, do we need a ruling from the board allowing that? The division doesn't object to them being recognized as experts?
So recognized.
Thank you. Also, with the board's permission, I'll be moving for admission of all our exhibits at the end of my case in chief. By way of brief background, Ovintiv is before you today, as the chairwoman mentioned, requesting a couple of simple things, 2 that the board has done fairly routinely, and 1 that is a little bit unique, and we'll spend some time talking about. The first request, as mentioned, is to reorient drilling and spacing units that were established under a pilot order. The second is to reduce the newly established DSU's heel-toe setbacks to what has become kind of the basin standard of 100 feet. And the third is to essentially manage the fact that there is a horizontal well drilled under the pilot orders in a different orientation than what is being sought today. And so we'll go through and talk about each of those. The relief requested today requires the modification and/or eventual vacation of Order 13990, and it also requires the modification and extension of Order 139-134, which we'll go through. Collectively, we'll refer to these as the current spacing orders or the current orders. With respect to the first requested action, reorienting the drilling spacing units in question, this was expressly contemplated in the pilot orders. It was kind of the design of the process was to establish, based on best evidence at the time, an orientation for drilling units and allow the drilling so that data could be compiled. Ovintiv is simply here to kind of prove up the concept of pilot orders. They drilled wells allowed under the pilot orders, have determined based on that data that these units need to be reoriented. So that first request is fairly straightforward. And they will be presenting evidence that shows these units should be established as laydowns and not as current stand-ups. As to the second requested action, the reduction of heel-toe setbacks from 330 to 100 foot. Again, this has become fairly standard practice over the last few years, as operator after operator has compiled sufficient data from their horizontal drilling programs to technically justify the setback. The 139-134 order, which we're seeking to have extended to cover the full acreage here, imposes currently 330-foot heel-toe setbacks on wells drilled. And so aspect 2 of Ovintiv's request is simply to have that portion of the 139-134 order modified so the heel-toe setbacks are 100 feet. As to the third request, I'm going to let the witnesses discuss this. Essentially, there's a well that has been drilled under the stand-up spacing orientation. It still produces economically, and so there's a real question, a policy question that's perfect for this board as to how to handle this reorientation and the new drilling. And they're going to go into detail in that in testimony. The board has jurisdiction over this cause pursuant to Utah Code 40-6-5 and -6. Notice was provided as required under Utah law, excuse me, to all interest owners and to all relevant governmental agencies. Each of these mailings were sent to the address provided by the agency or to the last known address of record from the Duchesne County Recorder's Office. In addition, notice of this hearing was published in the Deseret News on September 1st, the Salt Lake Tribune on September 3rd, and the Uinta Basin Standard on September 6th. On September 11th, the division filed a response and notice of non-opposition to this amended request for agency action, noting that the division does not oppose the request, subject to sufficient proffer of evidence at the hearing. Again, I'd like to remind you, all interested parties received timely notice of the request, and there has been no filed letter or opposition in protest to this request. I would ask that the board infer from this that the parties who were notified implicitly agree with the request as sought today. With that, I will move into my examination of Mr. Ellison.
Very good.
Okay.
Let's do it.
Mr. Ellison, can you please state your name, spell your last name, and state the corporate business address for the record, please?
Sure. My name is Ashley Ellison, E-L-L-I-S-O-N. And my business address with Ovintiv USA Inc. is 4 Waterway Place, Suite 100, The Woodlands, Texas, USA 77380.
Okay. And your position with Ovintiv and your area of responsibility?
Sure. I'm a senior land negotiator with Ovintiv. There's 3 of us, and we kind of share this area of the basin, I suppose.
Okay. And you have responsibility over the lands at issue today?
That is correct, sir.
Okay. Can you give a little bit of corporate and bonding status for Ovintiv, just for the board?
Sure. Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and merger of Ovintiv Production, Inc.
Okay. Now, I'm going to flip through some of the exhibits that I want you to discuss today. Exhibit C, D, E, F, and G. Do you recognize these exhibits?
Yes, sir.
And were they all prepared by you or under your direction or supervision?
Yes, sir.
Okay, starting off with Exhibit C. Can you just simply help the board quickly orient as to where this unit or these units are located in relation to the other areas in the basin?
Sure. The red outlines comprise of section 3 and 4 and 9 and 10 constitute kind of two lay-down 1280 DSUs, more or less. And they're located approximately 1 mile south of Upalco, a half mile north of Arcadia, and 4.5 miles west of Ioka.
And to be clear, the red hash there, that is the proposed orientation. They are not oriented that way, correct?
That is correct. Excuse me.
Thank you. Turning to Exhibits D and E, which we'll probably deal with together, if that's okay. Exhibit D and Exhibit E. Quickly, just tell the board what these show at a high level.
Sure. In the simplest terms, Exhibit D shows the existing wells on the subject lands. And then Exhibit E identifies the spacing orders applicable to the subject lands and the surrounding area.
Okay. So for Exhibit E, can you walk through the spacing orders that we're requesting the board modify here today and how they apply currently?
Sure. So red is the proposed DSUs, and then...
This red square in the middle?
Yes, that's correct. 3 and 4 and 9 and 10. The west side of those DSUs is currently spaced on order 13990. That's represented by the yellow dots. So that's sections 4 and 9. And then the eastern side of those two laydown DSUs is order 139-134, and that's the blue crosshatch.
Okay. And what does the 13990 order establish?
Sure. It establishes sectional 640-acre drilling units, and each of those units are spaced at a 640-acre production unit under that order.
Okay, so 4 and 9 are currently not spaced as the 1280.
That is correct.
Okay. Order 139-134, relevant to this discussion, it looks like it establishes a stand-up.
Sure.
Would you please walk the board through that?
Sure. So 139-134 establishes a 1280 long lateral horizontal kind of stand-up area. And it's effective for, so it establishes the 1280, and then it also establishes a conversion for the wells that were already drilled in those units. And then kind of the background of conversion is the conversion's effective for the existing verticals and short lateral horizontal wells as of the first of the month following the date of first production of the first long lateral horizontal well. And then it's effective as of the date of first production for that first long lateral horizontal well.
Okay. And so I guess for the board who's probably heard about Aventa's conversion orders often, it's the same conversion process.
Exactly the same conversion process.
Okay, thank you. So just to clarify, the requested setback reductions will be effective immediately.
That is correct.
Okay.
Yep.
Looking at Exhibit D, we'll go back to that if we could. So the 3 and 10 are established, as you just said, on a stand-up 1280 basis. 4 and 9 are each on sectional 640 bases. Could you please walk the board through the wells that have been drilled and are currently producing on the subject lands?
Yep. We'll start with the blue. So section 4 has the Evans well, the Evans 1433. It was spud in 2011, and it's currently spaced at the 640, not 648, 640 allocation. For that well, there was no compulsory pooling order was sought, and the Evans well has yet to achieve 100% payout.
Okay. Section 9?
Sure. Section 9 has 2 wells drilled in it. The Gilbert well is the vertical well in the the eastern side of Section 9 there. It's operated by Oventive, 640-acre allocation, and I guess I'll talk to the Patterson well. They're kind of both force pooled together, I suppose. Yep. The Patterson well is the short lateral horizontal in Section 9. Both of these wells were compulsory pooled by Order 139-105. They were assessed a 300% risk penalty, and there's 4 parties. And full recoupment under that order, 139-104, has not yet occurred.
And for sections 3 and 10, there, it clearly looks like a well there. Can you tell the board about that?
Sure. So that's the P rank, everybody's favorite well. The P rank 13-10-333-WH. It's operated via Oventive. It's a 2-mile lateral. There are 2 estates that were we established a non-consent penalty, compulsory pooled of 300% in order number 139-119. And full recoupment is under this order has not yet occurred.
Okay. So would it be fair to say that the P rank is the pilot order well?
Yes, that is correct.
Okay. Just to sum up, section 4, there's no recoupment concerns.
Yep.
Sections 9, 10, and 3, there will be recoupment to deal with in some way.
That is correct, sir.
Okay. The requested issue today, if approved, would mean the Evans, Gilbert, and Patterson wells convert from 640 allocation to 1280 allocation going forward. Is that right?
That is correct.
Once a well is drilled.
That's correct.
But the P rank, under the request, the amended request submitted, will not convert to a different 1280 allocation. It's going to remain payable on a section 3 and 10 allocation. Is that correct?
That's correct. The one long lateral horizontal will not convert.
Okay. Given that nuance in this case, probably different than what the board has seen in prior causes, can you briefly discuss for the board how recoupment, as discussed in the 139-134 order, the spacing order that authorizes the P rank well, can you discuss how recoupment will be handled going forward with respect to the pooling orders you just discussed, the pooling orders covering the Patterson and Gilbert in section 9, and the pooling order covering the P rank in 3 and 10?
Sure. Any recoupment still owed under the 139-104, so the Gilbert and Patterson wells, will be waived so as to allow for go-forward participation in those converted DSUs.
Okay.
In contrast, the P rank well, if approved, will be maintained on its sections 3 and 10 allocation and will not convert to the new allocated well requests. Any recoupment still owed under order 139-119, the P rank one, will not be waived.
Okay, so because the P rank isn't changing allocation,
That's
isn't
correct.
going to be paid in a different way, it doesn't make sense. It's not fair to anyone to waive that recoupment.
That's correct.
Okay. Switching gears a bit, one final question with this set of exhibits. Can you tell the board whether there are any tribal minerals at issue in these subject DSUs?
Sure. The majority of the minerals, roughly 2/3 of these 4 sections, is tribal minerals. The remainder is fee, I guess.
Okay.
Yep.
And I'm assuming a spacing order such as this is probably a necessary prerequisite, if not a practical prerequisite for CA.
Yeah, generally when Indian minerals are involved, a spacing order order not only facilitates, but it is required for the BLM and the BIA's approval of a conforming communitization agreement, or CA.
Okay, perfect. Moving on from those 2 exhibits, Exhibit F, notice area. Can you please walk the board through this exhibit and tell them what it shows?
Sure. This exhibit shows the area we notified of this request, including the subject lands and surrounding area.
Okay, and you're familiar with the certificate of service and the supplements there too that are on file in this case?
Yes, sir.
Okay. The names, who's on that list?
Sure. So the names represent all the production interest owners within the subject land, so the crosshatch, the 4 sections.
Okay.
And then we also notify all working interest and unleased mineral interest in the surrounding land, so the solid pink.
Okay. And how did you get that list of names?
Sure. Yep. The names and addresses were compiled from Oventive's internal land records, including title opinions and a search of the BIA and Duchesne County records prior to filing the RAA by Lone Wolf Energy. Lone Wolf is Oventive's contracted land service company, so they do all this kind of work with us.
Okay. And I'd just like to remind the board that Lear & Lear, on behalf of Ovintiv, mailed a copy of the request to all these parties by regular mail, not certified mail. Moving on to what will be your last and hopefully very short exhibit. Would you please tell the board what the purpose of this exhibit is and what it demonstrates?
Yeah, sure. Basically, this kind of just shows that we are clearly the majority working interest owner in these DSUs.
Regardless of orientation.
Yes, regardless of orientation. That's correct.
Perfect. With that, I'm done with Mr. Ellison and subject him to division cross.
Thank you. With the board's approval, division staff has some questions for this witness.
Yeah, Dustin Doucette, engineering manager for the division. You'll turn to Exhibit D. You had mentioned on the P-rank well that 139, 134 order allowed for conversion, but in this case there were no wells to convert when that was drilled. Is that correct?
That is correct, sir.
Okay.
Yep.
And just to follow up on a couple things, and you may not be the best to answer this, but on the P-rank well, you had mentioned it will not pay out or hasn't paid out. Was that the 300% or is that at even 100%?
Oh, sure. That's even 100%. I checked into that, and we're a long ways away from reaching the 100%, and then even further the 300%.
So working interest owners in this well won't even make the money back on that well.
No, that's correct. Yeah.
And just going down the line, you don't think it will pay out at 100% in the future?
It will. I would say no. The payout was something like the 34,000 months is what I checked into that. So it's not, at the end of the day, it is not the greatest well. It's us and then XCL as the other working interest owner. They make up kind of the difference, I suppose.
Okay.
Yep.
That kind of went into my next question on Exhibit G.
Sure.
So I think you kind of indicated. I wanted to ask the carried unleased mineral interest and partner working interest on specifically sections 3 and 10. You mentioned XCL was a partner. Do you know about what percentage of that box that makes up?
Yes, I think they own roughly 5%.
5%. So there's 9% unleased mineral, roughly?
Yeah, that's correct.
Okay. And then on the other sections indicated on the new DSUs, are those similar ownerships in the other sections as well, or is it?
Sure. So, yeah, good question. So we did buy out XCL's interest in future wells, I guess, in this area. So XCL only owns interest in section 3 and 9, which is why those numbers don't necessarily kind of add up if you're just doing the 14%. So we did acquire that interest, and then I'm sure over the course of I think the P-rank well was drilled in 2014. We've been successful in leasing, I'm sure, a fair amount of the unleased owners. But there are no other working interest owners in these 4 DSUs.
Okay, thank
Yep.
you.
Yep.
No other questions, thanks.
Any questions from the board for Mr. Ellison at this time?
Yes, same question as Mr. Doucette had on section 4 and 9 on Exhibit D. Have they paid out at 100 or not paid out at 100, not paid out at 300?
Sure. I think the only well that is paid out to 100% is the Gilbert well.
Okay, so it's someplace between 100 and 300, and the others are not yet to 100.
That is correct. These are not the greatest wells in the basin, I would say.
And they're over 10 years old, so they're
That's
not
true.
ever gonna, okay, thank you.
Any other questions from the board?
So when the horizontal wells are drilled, lay down, should this be approved, what will their proximity setback vertically be from the pre-rank well?
Sure. I will yield my time to the smart people that will be answering.
Okay.
Yeah, so.
But I assume.
They'll get to that, yeah.
But I assume that you still anticipate unleased personnel in that where you will probably have to go to a compulsory type of situation again.
Yeah, there's generally just a few people that we can't find in any given area, I suppose, through airship issues that potentially we might have to compulsory pool at that point.
Thank you.
No other questions for Mr. Ellison at this time. I'll have him sit, or actually you can stay there. Just shut your mic down if you'd like.
I will shut it.
And I'd like to call my next witness. Mr. Jennings, are you available and ready, George?
Yes, I am.
Okay, good. Well, let's start off then. Would you please state your name, spell your last name, and business address for the record, please?
Sure. My name is George Jennings, Jennings. I work at 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
Okay. And what is your current position with Ovintiv generally and with respect to the lands here today?
Yeah, I'm a development geologist working the Uinta Basin.
Okay. And in that regard, do you work on the lands here under consideration?
Yes.
Okay. Thank you. I'm going to do similar to what I did with Mr. Ellison. If we could go through your exhibits that you're going to testify about. I'm going to show you exhibits H, I, J, and K. Can you see those okay?
Yes, I can.
Okay. Do you recognize those exhibits?
Yes.
And were they prepared by you or your team under your supervision?
Yes.
Okay. Thank you for that. Back to exhibit H. Please tell the board about this type log.
Sure. So this is on the left there, you'll see the Shell Brotherson 1-11B4 type log, which is where we've defined the stratigraphic definition for the lower Green River to Wasatch transitional formations, orders 139-134. It also is highlighting the 5 primary target zones that we typically target. On the right side there, you'll see a map indicating where the type log is relative to the application lands.
Okay, perfect. Thank you for that. Exhibit I.
Sure. This is also another type log in a similar format to the previous one. This is the Evans 1-4-3-3, which is located in the DSUs that we're talking about here. This just highlights how the basin type log relates to this particular area and highlights again the 5 primary targets that we typically drill, and also the 8 potential horizontal targets that are in the sections.
Okay, so this is essentially taking your basin-wide understanding and correlating it to these specific lands?
Yes, that's correct.
Okay.
Additionally, you'll see, oh, sorry, go ahead.
Sorry, I just didn't know if I cut you off, but apparently I did a second time. Go ahead, Mr. Jennings.
Oh, I was gonna also just mention that the P-rank well its landing target is highlighted here in the middle Wasatch below the 5 primary targets that we typically drill in.
Okay, so just to clarify, it is within the productive interval you're seeking to space. It's just located below what you would consider your current 5 primary targets.
That's correct, yes.
Thank you for that. Exhibit J. Could you quickly walk the board through what this cross-section shows?
Sure. This cross-section is just showing the type logs going from west to east through the DSU. And really, the point of this cross-section is just to reflect the uniformity that's present in the area. You can see nice, consistent stratigraphic packages here. And it really highlights that the lower Green River Wasatch transitional formations constitute one common source of supply in this area. And it's consistent with the board's designation of those formations as one pool throughout the Uinta Basin.
Okay, perfect. Finally, moving on to Exhibit K. Just to note here, it references the Thorn UT well. That is a well you've used on one of your other slides, and I'd like you to refer to that if you could for us. Where that comes from. Oh, never mind. I apologize. I'm ahead of myself. I was thinking of Christopher's testimony. Please go ahead and describe this slide, Mr. Jennings.
Sure thing. This map here indicates kind of the maximum stress. It's a map of maximum stress. And you can see the maximum stress indicators from individual wells are displayed on the map. And then the general gridded average of those indicators shown here. You can see that we have in the Evans well in the section, we have an actual stress indicator there. And in general, the average of the closest wells with the stress indicators, they average a maximum stress. They have an average maximum stress of 10 degrees northwest.
Okay. And based on all of your testimony here today, would you, in your expert opinion, would you say that the lower Green River Wasatch constitutes one common source of supply for purposes of this hearing?
Yes.
Okay. And would you say, in your expert opinion, that the data you've uncovered through your pilot program and additional drilling has indicated to you that these DSUs should be oriented for maximum production in a lay-down orientation rather than stand-up?
Yes, that's correct.
Okay. With that, I am done with Mr. Jennings for now, and would allow the division to cross.
Division staff has some questions from this witness.
Yeah, Dustin Doucette again for the division. If you could turn to Exhibit I. So on here, you identified the P-rank well as being in the middle Wasatch, which is not one of your primary targets in this area going forward. Is that correct?
That is correct. It's yes, that's correct.
And then just as far as the Gilbert well, what zone was that drilled in, or what horizon?
The P-rank?
Gilbert? You mean
Gilbert.
the Patterson?
The Gilbert, wasn't that the other horizontal? Or was it the Patterson?
I thought it was.
Oh, sorry, the Patterson. My fault.
Yeah, the Patterson 4-9-3-3WH W15, I think. Trying to read my chicken scratch there. But the 5K on the western side of the DSU, of the southern DSU there in section 9 is also a middle Wasatch well.
Okay, so your intent's not to drill these horizontals, at least initially in those zones. How far away from, the middle Wasatch is your closest potential horizontal going to be in these DSUs, proposed ones coming up?
Sure. I mean, so you can see on the Evans type log there, the center of the middle Wasatch is about 10,250 feet TVD, and the upper Wasatch, the middle of that would be somewhere around 9,000, around 8,000 or 9,000 feet TVD. Or, I'm sorry, not 9,000, 9,000, close to just below 10,000, or just above 10,000 feet TVD. So you're looking at, around 250 feet. However, regardless of that distance between those, we really want to just focus on maximizing our resource recovery and minimizing waste. And, we feel that, this is the best way to do that.
So you don't believe you'll come within 250 feet of those existing wells, at least in the near future? Vertical
That
distance.
is not our intent, no. Our intent is to drill the 5 primary things, but we are spacing all of it.
Correct, yeah. And I don't know if you know, like, at least the 139, 134, I believe that allowed 100-foot vertical separation between wells. Is that correct? Or do you know that?
In the same producing interval, I
in the
think?
same
Yeah,
producing interval.
I think
yeah.
so.
Yeah, and Chris is going to provide some evidence supporting kind of these types of well crossings. So perhaps he might be able to shed a little bit more light on this.
And maybe this question's for him as well. Just as far as the P rank, where is it in its life as far as productive life? Would this be a better question for him, or can you answer that?
That would be a much better question for Chris.
Okay, I'll hold off on these next couple of questions. Okay.
Production is a little bit out of my expertise.
Okay, I think that's all I have.
That's all from the division.
Back to Mr. Mayo.
If there are no questions for Mr. Jennings right now, I'll let him take a break and we'll bring Mr. Wall up. Obviously, we have time to ask
Can I
questions.
interrupt you?
Of course.
We need to check with the board to see if there are any questions.
So this was I pronounce it prank because I've heard prank. It's anyway. In the Middle Wasatch, that's fairly uncommon. Was it just a testing the Middle Wasatch? Because normally started out with the Uteland Butte and Castle Peak and Upper Wasatch. Are you aware of why it was the thought, what went behind the Middle Wasatch decision in 2014? You weren't there, but.
So I was not with the company in 2014, so I can only speculate on why that was targeted, but that was pretty early on in the drilling program. I imagine that at that point, it was still an exploration target.
Okay. And then one other question, Mr. Ellison. Pulling it up on the website, it's produced 303,000 barrels of oil in its life.
Okay.
How is it not paid out once, even at $50 a barrel? That would be $15 million.
Sure. I asked for the payout statements from accounting. I am happy to follow up with accounting with those specific questions. I don't know the answer to that.
I know
aspect.
oil was less than 50 at
Sure,
various
and
times.
I
And
honestly-
maybe when it come on, it was 30 bucks a barrel.
And there might have been issues. It might have just been an expensive well to drill.
Okay.
There could be workovers that have occurred over the last that type of aspect.
Yeah, because the production was down in the hundreds last year, and now it's around 1,000.
Sure.
Well, now it's back down. Anyway, it's
No, I
been
get
all
you.
over the place. Looks like it's had some work done.
Sure. Yeah. It's a good question.
One thought might be, I remember from compulsory pooling hearings back in that time, well costs were typically 12 to 13 to 14 million, whereas now we see more 8 to 10. So it could explain some of it.
Yep. And wells are also a lot cheaper if you batch drill them, I suppose, and that was a single well. Yep.
Board? Mr. Church?
So, Mr. Jennings, I also wondered, the wells in section 5 and 8 are both vertical wells. Are those in the Middle Wasatch also? And what has their performance been?
I don't know if I can speak to their performance. I'm also not I don't know, I'm not a production engineer, so I don't know exactly where those are perfed. Yeah, I can look into that.
Okay, them being both vertical up and down, and the per rank well also. These were all drilled after the Evans well, is that correct? And with the stress direction information coming out of the Evans well, It's kind of a puzzle to me is why they would be drilled in a stand-up position rather than horizontal if that data was already available.
Again, I wasn't with the company in 2014, so I can only speculate, but we've placed, I think it's only been in the last several years that we've really understood how important that there's a change in maximum stress direction here. So in the eastern part of the basin, it's maximum stress runs east-west, which is through most of the basin, and it's only on the western side of this basin here that it changes to be a north-south orientation. And I know that there's been an enhanced emphasis on understanding that because of the poor production that we've seen in some of these stand-up wells in this part of the basin.
And so also, would you say that there's more information about productivity in the zones that you will be targeting up above the Middle Wasatch in this area, and that perhaps the performance has been, because the Middle Wasatch is not as productive as the upper zones that you'll be going after?
Yes, that's definitely true. The primary targets are, have higher oil in place and are just generally more productive zones.
Thank you.
Any other questions? Sorry, Mr. Mayo, you may continue.
Please, no apology. With that, I'll probably let Mr. Jennings rest. Please, George, don't go far. Hang on and listen. There may be follow-up questions as this hearing continues.
Absolutely.
Thank you. With that, I'll call the final witness for this matter, Mr. Christopher Wall, who I accidentally called Christian 6 times yesterday, even though his name is Christopher. So, Mr. Wall, are you there?
I'm here. Can you hear me?
I can. Yeah, you can hear us okay?
Yes.
Good. And you heard Mr. Jennings and Allison's testimony as well? Allison.
Yes, sir.
Okay, would you please state your name and spell your last name and your business address for the record?
Yes. My name is Christopher Wall, W-O-L-L. My address is 4 Waterway Place, Suite 100, Woodlands, Texas, 77380. And I am a senior reservoir engineer with Oventive, working the Uinta Basin.
Okay, thank you. And do you have a particular knowledge or working relationship with the lands here at issue today?
Yes.
Okay. Could you, I'm going to do similar with the others. I'm going to walk you through some of the exhibits and have you just authenticate them for us. Exhibits L, M, N, O, and then a 2-page exhibit at the end, Exhibit P. Do you recognize those exhibits?
Yes.
And they were prepared by you or under your direction or supervision?
Yes.
Okay, thank you for that. Starting with Exhibit L, would you please help the board understand what this is? And I'd like to note at the beginning, as you can see in the bottom, this is not to scale.
Yes. This exhibit reflects the comparison of requested setbacks. Here we're showing the orientation of the 10 degrees north by west, effective fracture half lengths of no more than 110 feet from the Uteland Butte wells. So the requested setbacks will prevent waste and maximize natural resource recovery, and correlative rights are not adversely affected.
Okay. Can you talk through the drainage calculation and how you come up with the kind of ellipse of drainage here that?
Sure. The drainage calculation is based on Hales and Evers of 1981. The parameters, the input parameters from the Thorn UT 421 3-2-16-7H, which is on Exhibit K. What we're showing here is that there's no drainage of adjacent lands at 5 years, and then minimal drainage, if any, of adjacent lands 10 years and beyond.
Okay. Exhibit N, can you talk through the oil in place and what you anticipate to be able to recover if this is approved?
Yes. So this table is at the ARAA density of 17 long lateral horizontal wells with an estimated oil in place of 332.9 million barrels and a total EOR of 9.9 million barrels for full development. The expected recovery factor of 3% with those 17 long lateral wells per DSU is a reasonable recovery factor.
Okay. And so those numbers you just gave, that's for full development of all 17 wells that we're requesting be permitted here today? Or
that is correct.
Thank you. Economics. Obviously, it's a reasonable rate of recovery factor. Economics. How does it fare?
So, with this particular exhibit, what we're showing is the comparison of 330 setbacks versus 100-foot setbacks. And the economics clearly favor the requested 100-foot setbacks. As you can see, the positive variance between the two, and especially you're getting, additional revenue, which is additional severance taxes and royalty revenues with the 100-foot setbacks versus the 330-foot setbacks.
Okay, so this economics just shows, because there are no additional wells being requested, this just shows basically the change in economic impact of the 330 to 100-foot heel toe setback.
That's correct.
Okay. Last exhibit, we've talked a lot about the P-rank, however you want to call it. Well, it's one of those unique situations. And Exhibit P, you kind of talk through how Ovintiv decided to treat it and how it's protective of correlative rights. So can you walk the board through this data?
Sure. So this exhibit provides some examples of the impacts of offset completion activity against the existing wells. So on this first page of this exhibit, you have two graphs. The one on the left is a data set of 3 wells. You're looking at the average production before and after the wells were offset by completion. That distance was a max of 500 feet. So this is a data set that's within 500 feet of an existing well. And what you see is that there is actually some uplift initially seen on these wells, and then at least on the oil production, and then went back on decline. And the graph on the right is a larger data set where we expanded our zone of influence to around 1,700 feet. And from this data set on those 35 wells, you didn't see any impact of offsetting completion activity.
Okay.
So on the second page, what we're trying to demonstrate
Before you move on, can I just ask to clarify one thing? You said, that almost that you see on the first set of wells, you see an uplift initially, and then it goes back on decline. Can you tell, do you have the data to say whether that's kind of, it returns to its natural decline curve, or whether that decline is accelerated in some way? Any kind of extra information about that return to decline?
It appears that it returns to its original decline. So there's a bonus or flush production, but it doesn't necessarily mean that you've accelerated the return or the oil production here. So it would be a reserve add, if you will, or an increase of production from the well. It's a benefit.
As far as you can tell, it's a short-term benefit with a return to what it was going to produce originally.
That's correct.
Okay. Sorry for interrupting. Now, you said the second page?
So on the second page, we were looking for a very specific example, knowing that we're going to be crossing laterals here. So this is the best example that we could find in the basin, where we have a north-south well. It's a 5K that was drilled north-south, and then we drilled another well east-west. Those well bores came within 125 feet of each other when we completed them. And what we saw was actually an increase in production and in the north-south well after the completion activity. And it is still above its original decline. So again, in this particular case, this well saw a benefit from the activity, the canoe completion. And really, we bring this up because this is probably the most pertinent to the Parank well. And it would suggest that the Parank well would not be negatively impacted by cross-laterals interaction with the completion.
That makes sense. If there's impact, the data you have before you says it's most likely to be a short-term positive impact to the Parank.
Potentially, yes.
Potentially. And just to remind, this is an example you pulled, you said, of an existing producing north-south well and a new east-west well. So directly analogous to what we're talking about here today.
That's correct.
And when you talk about 125 feet away, do you know off the top of your head whether that's vertical or laterally or kind of at a? They both targeted the Uteland Butte, as I understand it.
That's correct. Both of these wells targeted the Uteland Butte, so 125 feet was within the same interval. So this would be lateral, wellbore to wellbore, toe to middle of the lateral.
Okay. With that, I have a couple follow-up questions if I can. I'm going to ask you to put your expert stamp on a couple things, if you would, if you're comfortable with it. In your expert opinion, does the modification and extension of orders 139.90 and 139.134 to reorient these as two laydowns instead of stand-ups, is that supported by the reservoir analysis in your expert opinion?
Yes.
Okay. And the reduction of the heel-toe setbacks to 100 feet, is that also supported by the reservoir analysis and necessary to recover additional resource that would be wasted?
Yes.
Okay. In your expert opinion, will the requested setbacks, including the setbacks with the P-rank well, be protective of correlative rights to the fullest extent possible?
Yes.
And given what you've testified about and what you've heard testified about, in your opinion, is maintenance of the payment allocation for the Parank well on its current 310 payment allocation, is that justified based on the anticipated minimal impact to the Parank production?
Yes.
Okay. Thank you. With that, I have no further questions subject to cross.
Division?
Yeah, just we brought up briefly before the economics of the Parank well. We talked about that it hasn't yet hit 100% payout. Could you speak any more to where you think that well is economically? The reason I bring that up is because on Exhibit M, we talked about drainage and vertical drainage. Looks like at 5 years, it's about 85 feet there. And then we talked about the 5 different zones, the primary targets that you have. I just want to get an idea, where do you think the Parank would be in 5 years as you go about drilling these targets?
So the data that I have is that well is probably 30,000 barrels of oil remaining to drain. So it's near the end of its life, essentially. So in 5 years, if we're doing about 30 barrels a day now, it's, and I don't know what kind of decline rate we're on, so maybe we're at a 5% decline. So, we're nearing close to the end. I think maybe there's 15 years of life left in the well, potentially, depending on economics going forward, et cetera. So maybe we're talking about I don't know, what would that be? About a 20 barrel a day well in about 5 years? If that's what the question you were trying to, if I'm answering the right question, sorry.
No, that's great. Because we are requesting no setbacks, and so just trying to establish, what effect this could have long term. But division staff does have a couple more questions for you.
Yeah, if you, well, you're on Exhibit M, so that's perfect. So when you say there's limited effects, either at 5 years or at 10 years, drainage-wise, what does that mean? I mean, are you saying there's minimal, a little bit of pressure decline, but not a lot of fluid movement? What does that mean, I guess is the question.
Yeah, so at the end of 10 years, at the tip of that radial drainage, there would be little to no fluid movement, but there you would expect some pressure. I don't know to the magnitude. I'm not certain.
Okay. And then on Exhibit P, on the first page of Exhibit P, so these data set of wells, the 3 wells and the 35 wells, can you tell me where they're located in relation to the subject lands?
I don't know that I could accurately tell you exactly where they are, except to say that they are within the basin, and they couldn't. Most of them are going to be to the east because that's where the densest drilling has occurred. So that would be what we consider the central part of our asset, which is what we call Central Basin. And I'm not familiar enough with the towns in the area to kind of give you, exactly where that may be.
But do you feel they are analogous to these wells that you're potentially having similar intersections or setbacks?
Yeah, I think when you see George's cross sections there, you can see that the formation, although he's just doing a little section of it, you can extend these lines across the basin, and you see the same stratigraphy all the way across, so east to west. It's pretty consistent. So yes, I do think that these are analogous to these particular DSUs that we're discussing.
And then on the second page of Exhibit P, so it looks like this well in particular was producing 10 to 20 barrels a day before the frac hit and went up to 70, 80 barrels per day. Is that kind of what you're getting off of that plot?
Yes, that's correct.
And so I think you mentioned the Parank well was 30 barrels of oil per day. So I guess it seems to be a pretty similar situation, what potentially you could encounter in the Parank well. Would that be correct?
So the only distinction that I would say here is that the Parank is in the Middle Wasatch. This example is Uteland Butte to Uteland Butte. In our current development scenarios, we do not intend to target the Middle Wasatch. So we're still be, 250 feet away from this Parank lateral. So I think that's an important distinction. Now we may come back and drill Middle Wasatch in the future as we figure it out. But, currently we don't intend to target that interval.
Okay. I think those are all the questions I have.
No more questions from the division.
Board, please, Mr. Church.
Yes, so when you frack these wells, have you found that does the frack growth go upward when you frack in the Uteland Butte, for instance? Does the frack growth tend to go up stratigraphic section or vertical section?
It does. We do have evidence to support that there is vertical fracture propagation, at least with fluid. Now with proppant itself, what holds the fracture open, we don't have any evidence to suggest that how high that particular prop fracture goes.
But relative to the downward movement, you have not seen too much evidence about frac growth going down stratigraphic section or vertical section.
I think you would say that the downward vertical growth of the fracture is limited in comparison to the upward vertical growth.
So with the Middle Wasatch being 200 to 250 feet below the Uteland Butte, you'd say that's another reason that you don't see too much effect of these future wells having on that well.
That's correct.
Okay, thank you.
Any other questions from the board? Mr. Walker?
Yes, okay. So, on Exhibit P here, both the first and second page, is that positive uplift in production, is your explanation it's all due to the frac hit? That it lasted about 90 days or thereabouts, or?
Yeah, I think there's a couple of explanations. One, you've re-stimulated a very small portion of the lateral with this offsetting frac, but you're also pushing fluid, so there's a bit of a flood front that could be. So it could be one or both of those things going on that's causing this uplift.
Okay. And so this frac hit was 125 feet away, and you're asking for a 100-foot setback. So is it the orientation that allows you to say that the 100-foot setback is not going to cause violation of correlative rights?
Yeah, I mean, you bring up a good point. So when we drilled off azimuth, what's happening is that our fractures are running along the wellbore. So we're not getting a lot of drainage away from the wellbore is what's happening when we drill off direction like we did. And so when we cross this, we should be able to get really close to that well without interfering with its original completion.
Okay, I understand that. Thank you.
Mr. Moon?
So on this, go to back to the second page there. I understood once that when you come close to another wellbore, you, number one, close in the existing well, and then number two, maybe you don't frack a certain portion. Is that not true? Because I see no reason to do that if you're seeing evidence of improvement. But I just kind of answer how you normally do that.
Right. Yeah, there's a couple different practices. In some cases, you will shut in wells before you frack and during the frack when you're doing offset. In a lot of cases, we actually produce through the completion of the new wells. And in this particular case, we did not shy away from any stages. We did our normal completion. And then in the existing well, it looks like we did shut it in for a short period of time while we fracked and then turned it back on almost immediately.
Thank you. And then when you turn a well off and then back on, don't you see some uplift for a short period of time because the pressure is built? Could that explain some of the uplift, or do you think it's mostly because of the proximity of the frac?
Well, you don't multiply the production by about 8, right? When you have flush production from a shut-in. So it's not that. We don't get that kind of a build-up with the shut-in. We're talking maybe you would go up 10 barrels a day, but you're not going to go from 10 to 80 with the shut-in.
Thank you.
Any more board questions? Okay. Mr. Mayo?
Yeah, just briefly, I realize I've done kind of a poor job. If I can ask a couple redirect questions of the witness just to clarify some of the distance stuff and the options that have been talked through. Mr. Wall, this is a pilot well. the P-Rank well. It was drilled based on best idea, and this is something the board is going to have to contend with going forward, I would imagine. Can you talk through what the three options were facing you guys kind of before filing this, and why you ultimately made the decision that's in the request to essentially not avoid skipping stages? You know, the three options I see are plugging the P-Rank well, which is economically producing, skipping stages, or having an artificial setback from the P-Rank well, which may make all the new wells less economic. Can you kind of talk through what those options were and why you guys ultimately decided to request what you requested?
Yeah, I think you hit on the points right there. So the option number one of plugging an economic well, that's always not a good business decision to do. And it's still draining a resource that we're obligated to maximize. The second option of skipping stages is another poor economic decision. You know, every foot of lateral that we complete contributes to the production. It would also be a bit wasteful to not drain as much of the lateral as possible. And really, your third option there is really in line with option number two. I mean, we're talking about being able to economically drain a resource, and anything that you do to limit what you're able to complete would have a negative impact and would not be in prevention of waste.
That makes sense. I mean, I guess the sum up is there's no perfect way to protect relative rights in this instance and balance it against maximizing resource recovery and preventing waste. It's kind of one of those where the balance is a little messy. Is that your assessment, Ovintiv's assessment?
I think that's a fair statement, yes.
Thank you. One more clarification. Well, I think that's it. I'll leave it with that. No further questions for Mr. Wall?
Yeah. Can we go for a moment, just go back to Exhibit L? Okay. So if I'm interpreting this right, your horizontal lateral, you have a 500-foot setback from the southern lease line there.
560, that's right.
Oh, okay, excuse me, 560.
Sorry about the small type.
Yeah. And the tip of the frac is still 422 feet from the southern lease line. Why are we not thinking about tightening that? Or, I mean, if you're asking for 100 feet on the north-south lease line, why not?
Do you understand the question, Christopher, and where he's headed with that?
Yes, I do. And the reason for that is we intend to come back and drill on the lease line.
Okay.
And so if we narrow the spacing to the lease line, that would prevent us from being able to do that in the future.
There's kind of two schools of thought. You can move the setbacks as close as possible to try and make sure both units capture that resource up to the section line, or you can keep them far enough away so there's a functional third drilling unit between them that produces the 2560.
Okay, so you hold the lease that's south of this one then, too. That's what you're thinking about in the future, is that what I'm gathering?
Yes, that is correct.
Okay, thank you. Makes sense.
Are there any other questions? Okay.
With that, I'll briefly sum up. I think it's probably appropriate to move for admission of our exhibits first. Before I do that, I'd like to move for admission of exhibits A through P inclusive.
Okay, so admitted.
Thank you. Briefly in sum, as you can see, all the statutory and regulatory requirements for approval of this request have been met. Most of this request is fairly straightforward. Reorient these DSUs to the proper orientation following an effective utilization of a pilot order. to determine the proper orientation. Step 2, reduce the heel-toe setbacks to maximize resource recovery with what we know now is a still protective correlative rights barrier. And step 3 is really the only unique part that we're asking the board to do, and that's to understand that there are a collection of not so good options in dealing with the Parank well, and we believe we presented the best of the not so bad options for dealing with this pilot order well in the Parank. With that being said, I'd ask the board to approve the request as pleaded.
Thank you. Board, would you like to deliberate a minute or two? Are you? I'm sorry. I'm always missing someone. Just hold up your hand. Division.
Thank you. Division, just like to say, when we first received this request, we did have concerns about the no setbacks with the Parank well. After discussions internally and with Aventive and the testimony given today, we are supportive of this request.
Thank you. Now, board, are we ready to make a motion, or would we like to deliberate?
Make a motion.
Okay, go ahead.
I make a motion that we approve the request for agency action as requested.
I'll second that.
It's been moved and seconded. All those in favor?
Aye.
Aye.
Any opposed? That was a unanimous decision. Thank you. Yeah, Mitch, would you please prepare the order for the board?
I'd be happy to. Thank you.
Thank you. Okay.
Now I'm going to turn time over here. I'll step out of this seat.
Thank you. We're going to take a brief break here before the next issue, so
Thank you.
it'll be what, 15 minutes, 10 minutes?
Back on at 2:25.
Sounds good. We'll be off record.
Thank you.
We are back on the record. We're going to move on to docket number 2023-034, cause number 132-20. In the matter of the request for agency action of Ovintiv USA, Inc. for an order pooling interests, including the compulsory pooling of the certain non-consenting owners in the Abbott well, 13-30, 3-4-36-35-7H, and the Abbott 13-30, 3-4-36-35-46H well in the drilling unit established for the production of oil and gas in the Lower Green River Wasatch. Are we ready?
We are ready.
Thank you, Ms. Utley. Would you like to begin?
Yes, Ginger Utley of Lear & Lear on behalf of petitioner Ovintiv USA, Inc.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you.
Members of the board, thank you for your time and attention to this matter today. By way of brief introduction, as I mentioned, my name is Ginger Utley of Lear & Lear. I've worked with Fred McDonald and Mitch Mayo for a while now, so I feel like I know all of you personally, but this is my first time appearing here, so I hope you will be patient with my newness if it makes itself obvious, but I appreciate being here. With me today, appearing electronically, are Ovintiv's witnesses, Jordan Lair, Senior Land Negotiator, and Chris Wall, who we just heard from, Senior Reservoir Engineer. Could we please have the witnesses sworn in?
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Thank you. The resume of Mr. Lair was submitted as replacement Exhibit A with that of Kendall Brown. Mr. Brown is unable to appear today, so Mr. Wall will instead be testifying as Ovintiv's expert in petroleum engineering. Mr. Wall's resume was submitted yesterday as supplemental Exhibit A. If separately asked, Mr. Lair and Wall would verify the contents of their resumes are true and correct. Mr. Lair will provide factual and expert testimony as he's done numerous times in the past. He's been recognized as an expert in petroleum land management in multiple prior causes, including in May of this year. Mr. Wall has also recently appeared and was qualified as an expert in petroleum engineering in cause 130-24, the cause just prior. Presuming the division has no objection, I ask that the board recognize Mr. Lair as an expert in the field of petroleum land management and Mr. Wall as an expert in the field of petroleum engineering.
Division.
No objection from the division.
Board. So recognized.
Thank you. Also, as is standard, I'll be moving for admission of my exhibits at the end of my presentation. This cause requests the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 35 and 36 in Township 3 South, Range 4 West, USM in Duchesne County, or what I'll call the subject unit. The subject unit was established by board order entered on February 29th, 2019, in cause number 139-160. A true and correct copy of that order was submitted as petitioner's Exhibit B. Pertinent to this hearing, the 139-160 order expressly authorizes the drilling and completion of long lateral horizontal wells, such as the Abbott wells at issue in this cause. At the time of filing the RAA in this cause, the subject wells were and remain the only existing vertical directional wells producing from the subject unit, so no conversion is applicable. In accordance with the 139-160 order and the APDs approved by the division and BIA, Ovintiv drilled the Abbott UT 13-30, 3-4-36-35-7H well, and the Abbott UT 13-30, 3-4-36-35-46H well, or what I'll refer to as the Abbott wells. The date of first production for the Abbott wells was October 7th, 2022. Several owners of undivided oil and gas interests in the subject unit and Abbott wells have refused or failed to lease or otherwise agreed to bear their proportionate share of the costs of the wells, including Idaho Youth Ranch, Kate F. Markham, Kent Dukes, Scott Dukes, Susan Dukes, Tracy Lee Sherrill, and Mary Ellen Slemaker Benyon. Each of these owners received mailed notice of the RAA at their last address of record where an address was available, and none have objected to the pooling or otherwise responded to the RAA. On July 18th, 2023, proof of these mailings was filed separately in this cause as Petitioner's Exhibit V. There is, however, one update of which I should make you aware. Allen and K. Blood LLC, identified in the RAA, has since executed a lease with Ovintiv. Ovintiv therefore makes an oral motion to remove Allen and K. Blood LLC from the list of parties to be compulsory pooled today.
Board, do you have any concerns about removing them? Please proceed.
Thank you.
Yes.
Thank you. In short, at this hearing, Ovintiv seeks the compulsory pooling of the parties identified on page 2 of the request for agency action, accepting Allen and K. Blood LLC. In addition, some of the fee leases were granted by parties claiming by, through, and under the estates of certain deceased parties, as identified in the RAA, for whom no confirmatory or Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there's the possibility of some unknown party claiming through these estates who is unleased and not pooled. Collectively, I'll refer to these as the unknowns. Pursuant to order of the board entered on June 15th, 2023 in this cause, a notice of opportunity to participate, naming each of the unknowns, was published in the Uinta Basin Standard for 2 consecutive weeks. Proof of said publication was filed separately in this cause as Petitioner's Exhibit P. No party responded to that notice or otherwise tendered his or her share of costs for the Abbott wells. Ovintiv therefore seeks to have these unknown parties compulsory pooled and be declared non-consenting owners. As to the non-consenting parties, Ovintiv seeks the following: imposition of a 300% risk compensation award, imposition of the terms of a JOA materially the same as signed by other working interest owners in the drilling unit, and which terms have been previously deemed just and reasonable by the board in prior causes. During the recoupment period, the unleased non-consenting owners will be entitled to a 19.119391% cost-free royalty, representing the average weighted fee royalty in the drilling unit, calculated as of the date of the spud of the Abbott wells. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and implementing regulations. In addition to the published notice of opportunity to participate in the Uinta Basin Standard, notice of the filing of the RAA and this hearing was also duly published in the Uinta Basin Standard on July 5th, 2023, the Deseret News on July 7th, 2023, and the Salt Lake Tribune on July 2nd, 2023. The division filed a response in this cause on July 12th, 2023, addressing the same issues regarding the legal sufficiency of the notice of opportunity to participate as have been addressed in prior causes with Ovintiv, including in cause 132-19 regarding the Moon Well. In its response, the division concedes that because the NOPs in the instant cause are materially identical to those in cause 132-19, the division, quote, considers the board's ruling in that cause dispositive on the issue of whether the notices at issue in this matter are legally sufficient, close quote. In cause 132-19, the board determined the NOPs are legally sufficient, though the board has requested additional information be included in future NOPs. And I believe this is the last of the requests that it involves that particular notice of opportunity to participate. No other objections or responses to the RAA were timely filed. As none of the alleged non-consenting parties filed a timely response to the RAA pursuant to Utah Administrative Code R641-104-150 and R641-108-400, we move to enter an order of default against them. With that, I will begin with the examination of my witnesses. Mr. Lair?
Yes, ma'am.
There you are. Mr. Lair, can you please state your name and spell your last name and provide your business address for the record?
Sure. My name is Jordan Lair. Last name is Lehr. The business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380. And I'm with Ovintiv as a senior land negotiator with responsibility over this drilling unit, among others.
Thank you. And can you provide the corporate and bonding status for Oventive?
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production Incorporated.
Thank you. During your testimony, you'll be testifying about exhibits C through R in this cause. Have you reviewed those exhibits?
Yes, I have.
And were they prepared by you or Oventive personnel with your review and input?
Yes, they were.
Thank you. Let's start by looking at exhibits C through E. Exhibit C is up on the screen right now. Can you please describe to the board what exhibit C shows?
Sure. Exhibit C is just our general regional locator plat, which is showing the DSU for this compulsory pooling, being sections 35 and 36 of 3 South 4 West, which is approximately 2 to 3 miles northwest of Bridgeland and directly north of the abutting US 191 in Duchesne County, rather.
Thank you. Moving to exhibit D, can you describe this exhibit for the board, please?
Sure. Exhibit D is just the plat of the mineral tracts that comprise the DSU. So there are 13 different mineral tracts. Of note, tract 12 is tribal minerals and tract 13 is state-owned minerals. And as well, you can see the 2 Abbott wells discussed there in the north half of the north half. Both of the wells were completed and began production on October 7th, 2022, as was outlined in the request for agency action.
Thank you. Looking at corrected exhibit E, this was filed yesterday as a corrected exhibit. Can you describe what this exhibit is and what was corrected and why?
Sure. So the exhibit, as it states, is just showing the working interest within the compulsory pooled DSU that we're discussing here. The exhibit originally had some small minor inconsistencies with the figures listed, and so we wanted to correct that. As you can see now, the working interest for Oventive is approximately 59.8262% working interest. The non-op parties that have signed a JOA represent just under 40% working interest, and the total compulsory pooled interest here is 0.1930% working interest, which equates to less than 2.5 net acres in the DSU. And I think the whole point of the slide here is to just again show that Oventive is the majority working interest owner in the unit we're talking about. To kind of elaborate a little bit on the other working interest owners in the DSU, there is a bullet point here that's disclosing that effective January 1st of 2023, Oventive's acquired the former working interest in the DSU owned by UNOWAX LLC, WEM2 LLC, which is going to be the bulk of what that non-operated working interest that was committed to a JOA is. However, at present, the remaining lessee/working interest owners in the DSU are Kaiser Francis Oil Company, the successor to Seneca Oil Company, Salt Creek Oil and Gas, who's the successor to Bright Rock, PEC Exploration LLC, Snowbird Acquisitions LLC, and Otter Creek LLC as successors to Broughton Petroleum Incorporated. And again, all of these parties have signed JOAs with Oventives, the terms of which contractually govern well elections, including the elections made on the Abbott wells. Further, Oventive has recorded a pooling declaration pooling all existing leases pursuant to the authorization contained in the various pooling clauses of the leases, and Oventive is in the process of securing a communitization agreement pooling these leases with the tribal lease.
Thank you. Let's talk about those notices of opportunity to lease for just a second. You're familiar with those?
Correct.
And we filed, on file is exhibits F through M, which are each of the notices sent to the owners here. Can you please describe what these exhibits show and walk through each of them, F through M, excepting G, which is the notice that was sent to Allen and K Blood LLC?
Sure. So these are the various notices of opportunity to participate, to lease and or participate in the Abbott wells, along with the proof of delivery, which contain the JOAs. Exhibits N and O were attached to each. These are the official business records of Oventive. And going through each one, so Exhibit F is the notice of opportunity to participate that was sent to Idaho Youth Ranch. They are the owner of an unleased undivided interest in Track 3, which equates to a 0.007246% working interest in the DSU. Receipt was confirmed on October 25th, 2022, and no response was ever received. As we discussed, we're going to skip over Exhibit G, being that Allen and K Blood LLC has now leased to Oventive. So moving on to Exhibit H, it's the notice of opportunity to participate sent to Kate F. Markham, the presumed owner claiming by, through, or under the estates of Harley Bruce Markham Jr., Ruth McCormick Markham, and Harley B. Markham Sr. of an unleased undivided interest in Tracks 3 and 11, which equates to a 0.01268% working interest in the DSU. Receipt was confirmed on October 21st, 2022, and no response was received. Exhibit I, again, another notice of opportunity to participate for Mary Ellen Slimmaker Benyon. She's the owner of an unleased undivided interest in Tracks 3 and 11, which equates to a 0.160401% working interest in the DSU. And although delivery to her valid PO box was made, Ms. Benyon refused to pick up and accept delivery, and as such, no response was received. Exhibit J is the notice sent to Tracy Lee Sherrill, presumed owner claiming by, through, or under the estates of Harley B. Markham Sr., Ruth McCormick Markham, and William Lee Markham, owning an unleased undivided interest in Tracks 3 and 11, which equates to a 0.006340% working interest in the DSU. Receipt was confirmed on October 28th, 2022, and no response was received. Exhibit K is the notice for Scott Dukes, presumed owner claiming by, through, or under the estates of Harley B. Markham Sr., Ruth McCormick Markham, Harley B. Markham Jr., and Lillian Mary Molly Markham of an unleased undivided interest in Tracks 3 and 11, which equates to a 0.002113% working interest in the DSU. Receipt was confirmed on October 22nd, 2022, and no response was received. Exhibit L is the notice for Kent Dukes, presumed owner claiming by, through, and under the estates of Harley B. Markham Sr., Ruth McCormick Markham, Harley B. Markham Jr., and Lillian Mary Molly Markham of an unleased undivided interest in Tracks 3 and 11, which equates to a 0.002113% working interest in the DSU. Receipt was confirmed on October 21st, 2022, and no response was received. And finally, Exhibit M, the notice to Susan Dukes, who is the surviving spouse of Christopher Dukes, presumed owner claiming by, through, and under the estates of Harley B. Markham Sr., Ruth McCormick Markham, Harley B. Markham Jr., Lillian Mary Molly Markham, and Christopher Dukes of an unleased undivided interest in Tracks 3 and 11, which equates to a 0.002113% working interest in the DSU. Confirmed receipt on October 22nd, 2022, and no response was received.
Thank you. And can you please just describe the exhibits that were attached to those notices, exhibits N and O?
Sure. Exhibit N, it's the survey plat for each of the Abbott wells, which was, we discussed, sent with each notice. And then Exhibit O is the AFE sent with each notice. Mr. Wall will testify that the AFP was fairly close estimate of the actual costs incurred in the drilling of the Abbott wells.
Thank you. And can you discuss the estates?
Sure. As you mentioned, there are several lessors claiming title in various fee tracts throughout one or more of the estates of the following deceased record mineral interest owners, being Betsy Christine Cowan, Martha A. Munns, Betty Ann Hollenbeck, Michael P. McDermott, Burton H. Cowan, Minerva E. McDermott, C. Ed Flandro, Robert T. Cowan, Clifton O. Cowan, Ruth McCormick Markham, Denise Richardson Ahrens, Ruth V. Cowan, H. Bruce Markham Jr., Sarah Casper, Harley Bruce Markham Sr., Shirley W. Cowan, Jack C. Hodges, Virginia M. Cowan, Jim Cowan, William Harley Markham, Joseph Reed Cowan, William Lee Markham, Lillian Molly Markham, Christopher Dukes, and Lynette Richardson Adams. And for all these parties, either no Utah probate of the estates has been initiated, or if filed, they are incomplete in that there are no proper distribution made to the heirs or devisees. However, based on heirship affidavits and other inquiries and research done by Oventa's lease broker, Oventa believes it has leased all of their successors without an order from a Utah court confirming their succession. The possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore Oventa seeks to compulsory pool their interests.
Thank you. I'd like to refer the board to Exhibit P on file in this cause, the proof of publication from the Uinta Basin Standard. Can you just describe that, Mr. Lair?
Sure. As you said, it's the proof of publication. That notice was filed with the Uinta Basin Standard. It's prepared by yourself at my direction, and we have not received any responses to that publication.
Thank you. Now let's talk about the JOA, which was submitted as Exhibit Q. Can you describe this exhibit generally?
Sure. So this is the form utilized is a standard industry form supplied by the American Association of Professional Landmen. It's Form 610. This is the 1989 version with modifications to address horizontal wells. The terms and conditions contained therein, including the modifications made, are consistent with the JOAs executed by other working interest owners in this particular drilling unit and are commonly found in more recently developed horizontal well drilling units. Oventa has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, EP Energy, and other major Uinta Basin operators.
And page 7 of the JOA discusses the non-consent penalty. Can you talk about that?
Sure. So as we said, this is the non-consent penalty. And in this particular JOA, it's filled out with 100% and 300% being provided. That's the same as contained in the JOAs signed by other working interest owners in the drilling unit.
Thank you. And Exhibit C of the JOA, can you talk about that?
Sure. It's the COPUS accounting procedure. Again, very standard industry form, pretty much universally utilized, and is similar to other JOAs in the Uinta Basin.
Thank you. Can you discuss the interest rate that appears on page C3?
Sure. So on page C3 is the interest rate. Article 3B sets the interest rate at the prime rate published in the Wall Street Journal plus 3%, which is fair compensation and to encourage timely payment of chargeable costs and expenses.
Thank you. And page C9?
So C9 is outlining the overhead charges. So here we've got $10,900 as the drilling well rate, and then $1,090 for the producing well rate.
Thank you. In your expert opinion, are the terms and conditions of the proposed joint operating agreement fair and reasonable and consistent with those accepted by other working interest owners in this DSU and with those commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes, they are.
Thank you. That's all I have for Mr. Lair, if the division would like to cross.
Yeah, I just have one question. We go to Exhibit E. Yep, we're there. In the original Exhibit E, compulsory pooled interests were 0.1772%, and now they are 0.1930%. I just want to clarify, was that an adjustment on an interest that wasn't earned? There wasn't somebody else that was found or anything in there? Why did that change?
No. Thanks for the clarification there. Yes, the issue was kind of, I'm sure, as you could gather through the testimony regarding the NOPs, there was an incorrect assumption made about airship that caused that differential there. Basically, I didn't apply the right fraction to a party when I had calculated that originally. And so it threw it as a slightly smaller number. So when I went back and checked it, that was what caused sort of the slight differential. So not another party being added, but just not the correct interest being applied in the original exhibit.
All right, thank you. Thank you for that clarification. That's all from the division.
Actually, I misspoke. I do have a couple other questions for you, Mr. Lair. Utah Code Annotated Section 40-6-6.5, subs 6 and 8 provide that a compulsory pooled unleased owner is entitled to payment of the average weighted fee landowner's royalty during the payout period. This does not include federal, state, or Indian lease royalty. If we could look at correct why.
Sure. As you kind of discussed, this is the calculation for the average weighted fee landowner's royalty for sections 35 and 36, comprising the drilling unit as of the date of spud of the Abbott wells. The summation of the calculation is 19.119319%. Includes royalty provided in the lease forms attached as an exhibit to the JOAs, signed by the unleased working interest owners in the drilling unit. And the previously submitted exhibit contained on the last page 3 leases that were taken after the spud dates of the 2 Abbott wells. They were not included in the calculation, but they were shown. And so what we corrected was to remove those as they were not being counted in the number. They were shown erroneously as a typographical error.
Okay, so the average weighted fee royalty did not change with the removal of those leases.
Correct, yes. So the leases should never have been shown on the page because they were not being incorporated in the calculation. It's a typo oversight on my part.
Okay, thank you. And I'd like to discuss notice for just a moment. I'd like to refer the board to the certificate of mailing on file in this cause. It's a pleading prepared by Lear & Lear under Mr. Lair's direction. And Mr. Lair, can you just explain what the certificate of mailing is?
Sure, it's evidence we mailed the request for agency action to the requisite parties. The addresses therein were derived from a title opinion, which was effective as of March 21st, 2022. And we updated that information based on a search of the county records by our broker here.
And is that the complete notice list?
It is.
Thank you. And I'd just like to refer the board to Exhibit V, which I've mentioned earlier, which is the certified mailing return receipts prepared by Lear & Lear under Mr. Lair's direction. And Mr. Lair, can you just briefly describe
it's, as you said, the certified mail in that column are actually participating with unleased mineral interest, and that's why they're making their way onto the average weighted landowner royalty schedule here.
Okay, so their lease calls for a 20% royalty, but then they're participating.
So it's the Exhibit B to the JOA, and what Exhibit B is a lease form. And in the event an unleased mineral owner, such as these parties, were to non-consent a well, would be subject under the terms of the JOA to that lease. So they would effectively be leased during that non-consent period under that lease.
Gotcha. Thank you.
Are there any other board questions? Seeing none, back to you, Ms. Utley.
Thank you. I would like to call Christopher Wall.
Hello, can you hear me?
Hello, Mr. Wall. Will you please state your name, spell your last name, and provide your business address for the record?
Yes, my name is Chris Wall. That's WOLL. Business address 4 Waterway Avenue, The Woodlands, Texas 77380. And I'm a senior reservoir engineer working the Uinta Basin for Ovintiv.
Thank you. And as was noted at the beginning of this hearing, Mr. Wall has been qualified as an expert in petroleum engineering. Mr. Wall, I'm going to begin by showing you Exhibit S. Was this exhibit prepared by you or Ovintiv personnel under your direction?
Yes.
Great. And can you please explain what this exhibit shows?
This is the actual cost to drill, complete, and operate the Abbott wells through May of 23. That's 2023.
Thank you. And in your expert opinion, were these costs fair, reasonable, and can you describe this for the board? And can you describe this for the board?
Yeah, this is a plat of the nearby existing horizontal well development at time the Abbott well was spud, or the Abbott wells were spud. And to note, this is the first step out in testing the Upper Castle Peak this far to the west. It's the well that's shown in a pink color on the plat. Yeah, that's all I have to say about that. Sorry.
Okay, that's fine. Thank you. And Exhibit U.
So Exhibit U is about risks, and what I would say is drilling oil and gas wells is operationally risky. In the case of the Abbott wells, they were drilled offset to producing horizontal, which introduces the risk of depletion, which can inhibit mud properties, leading to lost circulation, increasing the risk of sticking drill pipe and sidetracks. And both the Upper Castle Peak and Uteland Butte formations have high clay intervals, increasing the risk of sticking drill pipe and casing. Specifically to the Abbott 46H, this encountered some operational challenges while drilling, resulting in extra drilling time, 2 lost drill bits, and a short lateral. So in addition, capital costs came in higher than expected due to inflation pressure across all operations.
Thank you. And in your expert opinion, is a 300% risk assessment award justified? And if so, why?
It is justified, and really it has to do with the amount of risk that the operators take on when trying to develop oil and gas assets.
Thank you. That's all I have for Mr. Wall. So I would turn it over to the division for any cross.
The division has no questions for this witness.
Board, are there any board questions?
Yeah, can we go back to S just for a second? I just needed to absorb those numbers. Wow, okay, thank you.
Go to T, if you would. So this 46H, you decided to just end it because you had lost a couple drill bits. It just wasn't worth going back in to finish that lateral on out.
Yeah, that's correct. At that time, we deemed the extra cost we would incur by fishing and then again sidetracking and trying to get the well to TD was cost prohibitive, especially in a risky area where we had never done an Upper Castle Peak area. So this was a test for us.
because that answers a question I had, because the production on these two wells is way different. The Uteland Butte's 291 today, 291,000 barrels, and the 46H is only 175. So you had a shorter lateral, plus it doesn't appear as productive anyway.
That's correct.
Even if you would have finished it, so, okay.
Are there any other questions? Back to you, Ms. Utley.
Then I would like to move for admission of my exhibits at this time.
Okay.
Replacement Exhibit A, Supplemental Exhibit A, Exhibits B through D, Corrected Exhibit E, Exhibits F and H through Q, Corrected Exhibit R, and Exhibits S through V.
Okay.
And in conclusion, as the evidence, oh, I'm sorry, did you have a question?
So you're not going to submit Z or G, which was the blood?
That's correct.
Okay. Go ahead.
In conclusion, as the evidence and testimony have established, all statutory and regulatory requirements have been satisfied for approving this request. All interested parties have been provided full legal notice of the request and the instant proceedings, and none have objected. Based on this, we would ask that the board grant the request as pled.
I'd like to go back just a second and say we will admit those exhibits.
Thank you.
Minus G.
Thank you.
Board, any final thoughts? I'm sorry, I'm looking at the division.
I know who you meant. It's all right.
Thank you. I'm looking in the right direction.
You know, when we submitted the initial response to this request, we raised issues with the notice and opportunity, the participation letters that went out. The board still has that concern. We feel like they're very minimal. However, we ruled on that. We've moved forward, and we're in the process of rulemaking as directed by the board. With that in mind, we're supportive of this request.
Thank you. Board, do you have any final questions before we? Okay. Do we need to deliberate, or are we ready to make a motion?
I'll make a motion.
Okay.
I move that we approve the RAA as requested.
I'll second that.
All those in favor?
Aye.
All those opposed? Please, for the record, it was unanimous. Thank you. Oh, and I keep forgetting, please prepare the
I'm
order,
happy
Ms.
to
Utley.
do that, yes.
Thank you.
you.
I'm new at this.
So am I. Thank you.
Okay. You want to take a 5-minute break? Are we ready? Can we take 5 minutes, please? Come back at 3:15. And we are off the record.
We are good to go. We're live.
We are back on the record and proceeding to the next matter, which is docket number 2023-038, cause number 132-21, in the matter of the request for agency action of Oventive USA, Inc. for an order partially vacating the order entered in cause number 139-121, and instead pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Powell Ute 1-12, 4-3-6-5-1H well in the drilling unit established for the production of oil, gas, and hydrocarbons in the Lower Green River Formation. And I would like to move to Mr. Mayo.
Appearance of counsel, Mitch Mayo of Lear & Lear PLC on behalf of the petitioner Oventive USA, Inc.
Assistant Attorney Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you, Mr. Mayo.
Thank you for that. With me today, again, I'm here on behalf of Oventive USA, Inc., petitioners in this cause, and with me today appearing virtually pursuant to board order issued on September 22nd are Mr. Peter Burns, Senior Land Negotiator, and Mr. Christopher Wall, Senior Reservoir Engineer. Can we please have these two witnesses sworn in at this time?
Please raise your right hand. Hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Yes.
Okay, thank you, guys. Board members, as is common practice, resumes of both of these witnesses have been submitted as Exhibit A, as part of Exhibit A. If separately asked, each would verify the contents of their respective resumes. Both have been recognized as experts by this board, Mr. Burns in petroleum land management and Mr. Wall in petroleum engineering. Presuming the division has no objection, I ask that both be recognized as such in this cause.
No objections from the division.
Thank you. Also, I'd like to confirm that it's the board's preference that I move for admission of my exhibits at the end of my case in chief.
That will be good.
Thank you. Before I begin with the summary, I'd like to give a little procedural history on what's going on in this case, if I can. This is a matter that was originally scheduled, I believe, a couple of months ago and has been continued given the board's busy summer docket. There is on file a fully briefed motion for summary judgment, or I should say partial motion for summary judgment, that addressed some issues that were anticipated to be raised as opposition in this matter. I'd like to remind the board those are completely unopposed, as is the partial motion for summary judgment, which is fully briefed and before the board. And although we've requested before this hearing to have a ruling pre-hearing on that, given where we are now, I think it's best, if the board's okay with this, to just reserve on that ruling, knowing that I'm not going to present any of the evidence or facts related to that. It's all in the briefing that's unopposed. And to remind the board, it's the identical briefing and the identical issue in a summary judgment that was granted by this board, I think, a couple of months ago. So what I propose is, given that procedural history, that we essentially put a pin in judging that partial motion for summary judgment and just make that determination as part of the overall determination with respect to the request for agency action. So I just wanted to kind of lay out some of that procedural history and give you an understanding and an opportunity, I guess, as a board to say, no, we'd rather argue it now, or we're comfortable granting it. But my suggestion is we simply reserve until conclusion of the case and make a decision on that in conjunction with the rest of the request.
Board, do we have any thoughts? I think that'll be fine to present it.
Okay, thank you for that. I'll try and summarize this case as quickly as I can, but it's a fairly involved pooling with a lot of interests. This cause involves the compulsory pooling of a drilling unit established for Lower Green River Wasatch production and comprised of sections 5 and 6, Township 4 South, 3 West, USM in Duchesne County. The drilling unit at issue was established by this board in Order 130-07, entered in August of 2021. A true copy of the 130-07 order was submitted as part of Exhibit B. Prior to entry of the 13007 order, Newfield, who is Ovintiv's predecessor in interest, drilled, and Ovintiv now operates, a vertical well, the Moon Well, located in Section 6, and that is the Moon 13-6-4-3W well, located in Subject Section 6. Production from that well has been allocated to date as on a sectional drilling unit basis pursuant to the board's 13990 order, entered in 2012. Pursuant to
If I may, when you mentioned that well, my family does have a interest in
in that
this
moon
drilling unit. Yeah,
that makes
Yep,
sense.
Yep.
Okay.
So need to just
There's no objection from Ovintiv. If this is a request for
Right.
an objection, there's no objection, but maybe a point of clarification. Will you be voting and deliberating as well, presumably?
deliberating but not voting.
Okay. No objection from Ovintiv, just trying to clarify for the record.
Okay.
Okay. Thank you for raising that. I should have caught that as well. A true and correct copy, well, sorry, let me back up. Pursuant to the order entered in August 2014 in cause 139-121, the board compulsory pooled the interests of several parties in that Section 6 drilling unit and declared them as non-consenting owners in the Moon Well. Full recoupment under that 139-121 order has not yet been achieved. A true and correct copy of the 139-121 order was submitted as the remainder of Exhibit B. The 130-07 order expressly provides for conversion effective, as with the rest of Ovintiv's conversion orders, as of the first day of the month following first production of a long lateral horizontal well drilled. Any recoupment remaining under the 139-121 order is waived or will be waived so as to allow development and production allocation on a, quote, go-forward basis for the two sectional drilling unit established thereunder. In accordance with the 130-07 order and APDs approved by the division, Ovintiv drilled the Powell 1H LLZ well, the well we're here to talk about today. Its date of first production was April 12, 2022, resulting in conversion to the two-section drilling unit basis as of May 1st, 2022. Consequently, Ovintiv seeks the vacatur of the 139-121 order insofar as it pertains to Section 6 and the Moon Well as of that date. As identified in the REA, and as Mr. Burns will address in his testimony shortly, there are several parties who were provided and received the requisite notices of opportunity to participate in the Powell 1H well, who have failed to timely respond or otherwise tender their respective share of costs for the well. As such, Ovintiv now seeks to compulsory pool those parties into the 5 and 6 DSU and have them declared as non-consenting owners with respect to the Powell well. The notices of opportunity to participate provided in this cause were identical in form to those the board ruled this March were legally sufficient under current existing regulations. However, recognizing the board's preference and the division's preference stated in those March proceedings, Ovintiv will prospectively include in such notices the party's specific interest in the drilling unit and the specific owner's share of estimated costs reflected in the AFE. This is, as we said, a matter that was filed back in the late spring and has been continued several times, which is why it still has the lingering notice issue. Since the filing of the REA, there have been a couple of adjustments that we need to make. There are 3 or 4. And there's one additional one today. Since the filing of the request in this cause, Cynthia Smith and Claudia Murthan, two of the parties specifically named therein to be pooled, have retroactively leased to Ovintiv. In addition, probate documents in regards to the estate of Lane Nielsen, a party specifically named to be pooled in this cause of action, have been received and reviewed by Ovintiv, and to Ovintiv's satisfaction, all of the heirs and/or devisees of the estate of Lane Nielsen are now voluntarily pooled, such that that estate will be removed as well. Finally, there's one last adjustment to make to the request parties, and that is to the interest of Janelle Hicks. She's identified in what we'll be submitting later as an exhibit to discuss the parties to be pooled. However, she has elected to participate and signed a JOA. So her inclusion on that list is a mistake, and we will clarify that during testimony. As a consequence, during this hearing, we verbally modify the request to remove from the parties being pooled Cynthia Smith, Claudia Murthan, Janelle Hicks, and the estate of Lane Thomas Nielsen. In addition to this, some of the fee leases were granted by parties claiming by, through, and under the estates of certain deceased parties. Although Ovintiv believes it has most of the parties who are entitled to a share of those interests under lease, it cannot be certain absent a court order, and they are named out of an abundance of caution. However, wait, I lied. There's one more correction to this, one additional estate that we need to remove from this request, and that is the estate of Clarice E. Bleckman. She was mistakenly listed as one of those decedents, but probate of her estate has been conducted in Duchesne County, and the conclusively determined sole devisee leased to Ovintiv back in 2014. Again, this is the last verbal modification.
Mr. Mayo, I'm not finding any of these people on this list
Other than Janelle Hicks.
other than Janelle Hicks.
That's good. Janelle Hicks was included on this list as an accident. This
Okay.
list should be the list of folks that take out all of these people.
Okay,
So none of them should show up on this list.
Okay, I
And
was confused.
We'll explain as we get to the testimony, but the request includes a lot of people, and especially given that this has been continued 2 months, a lot of leasing and document passing back and forth happens, so there's usually corrections. In this one, there's 4 or 5 that we need to correct, and this list should have none of them on there, but it accidentally has Janelle Hicks still.
Gotcha, thank you.
Thank you. As to any potential unknown heirs or devisees of the estates, as this board is aware, pursuant to order of the board entered on July 19th of 2023, a notice of opportunity to participate relating to this well, as required under 649-2-9A, was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to that notice or otherwise tendered his or her share of costs of the well, and Ovintiv therefore seeks to have all parties receiving notice to be compulsory pooled and declared as non-consenting owners. The proof of publication of the unknown heirs or successors was submitted as replacement exhibit GGG. As to the non-consenting owners, Ovintiv seeks imposition of a 300% risk compensation award and the terms of a JOA materially the same as that signed by other working interest owners in the drilling unit and which have been deemed just and reasonable by this board on numerous occasions in the past. During the recoupment period, the unleased non-consenting owners will be entitled to receive roughly 18% cost-free royalty, 18.046, representing the average weighted fee royalty in the drilling unit calculated as of the date of the spud of the Powell well. As I mentioned earlier, there's a procedural issue in this relating to International Petroleum LLC is the lessee under a couple of fee leases that involve the UDOT and DFFSL. Long story short, those go to the heart of the partial motion for summary judgment that is fully briefed and ripe for decision, and we will avoid discussion of too much of that to save the board from essentially regurgitating what's already on file in the briefs. Of note, IP, LLC, none of their entities have appeared today or filed an objection or protest in any way to this action. I'd like to remind the board that it has jurisdiction over this matter pursuant to 40-6-6.5 and the implementing regulations. A copy of this request was mailed, certified to the known parties to be compulsory pooled, including to UDOT and DFFSL, due to the fact that they are lessors under the IP LLC leases to be pooled. and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, whether they be Tribal, Ute Distribution Corporation, BIA, Duchesne County. This was also mailed to all of the relevant tribal and federal agencies as well. In addition to the published notice of opportunity to participate, as previously mentioned, notice of this hearing and the filing of the RA was also published in the Uinta Basin Standard, Deseret News, and Salt Lake Tribune in the first week of August. As the board will recall, this cause was continued from the August docket. No republication of the notice of hearing was required as a result of continuance. On August 9th, 2023, the division filed a response expressing no opposition to granting the request. No other objections or responses to the RAA were timely filed. Excuse me. As none of the alleged non-consenting parties, IPLLC, or its lessors filed a timely response to the RAA, pursuant to Utah Admin Code 641-104-150 and 641-108-400, Ovinta would move to enter default against those parties at this time. With that, I think I'm ready to proceed with my first witness, Mr. Burns. Peter, can you hear me there?
Yes.
Okay. Oh, there you are. Mr. Burns, will you please state your name and spell your last name and state your business address for the record?
Yes. Peter Burns. That's Burns. And Oventive's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay, thank you. And what is your position generally with Oventive and with respect to the lands under consideration?
Yes, I'm a senior land negotiator with Oventive with responsibility over this drilling unit, among others.
Okay. And Oventive's corporate and bonding status for the record?
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah, is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
Okay. And now I'm going to show you a couple of exhibits, if that's all right. Exhibit C, Exhibit D1, Exhibit D2, Exhibit E, F. Do you recognize these exhibits?
Yes.
And were they prepared by you or someone under your direction or supervision?
Yes.
Okay. Starting with C, will you just help orient the board as to where this specific drilling unit is located?
Yes, so Exhibit C is our regional locator plat. This with the subject DSU outlined in red. This drilling unit is just due west of Bridgeland with US 40 crossing through a portion of the drilling unit.
Okay. And Exhibit D, D1, I guess we'll start with. What is this exhibit? Where did you get it? And what does it show?
Yeah, this is an exhibit. D1 is a plat of our well location and oil and gas ownership tract descriptions. This D1 shows the general location of the Powell 1H well in sections 5 and 6 as it traverses the south half of the drilling unit. As outlined in the RAA pursuant to the 130-07 order and APDs approved by the division and the BIA, the Powell 1H well was spud on January 2nd, 2022 and completed as a producing oil well with productive intervals within the Uteland Butte member of the spaced Lower Green River Wasatch Formation. Date of first production was April 12th, 2022. Also reflected on this plat is an existing vertical well, Moon 136-4-3W, located in Lot 2, also known as the Southwest in Section 6. It was drilled in 2014 pursuant to the 139-90 order. Production was accordingly allocated on a sectional drilling basis.
Okay.
As Mr. Mayo mentioned, under the 139-121 order, 25 parties were compulsory pooled and declared as non-consenting owners in the 13-6 well. Full recoupment from them pursuant to this order has not yet occurred. Per the 130-07 order, allocation from the Moon well converted to the DSU basis as of May 1st, 2022. And all remaining recoupments were waived as of that conversion date under the 130-07 order.
Okay. So there appears to be a fair amount of tracks, 16 mineral tracks by my count in this DSU, and it's in irregular sections, right? This is not a 1280 typical section.
Correct. As shown on D1 and the subsequent D2, there are 16 different oil and gas tracks in this DSU, which is comprised of a total of 1,323.27 gross acres.
Okay.
Tract 1 is tribally owned, and tracts 9, 15, and 16 are 2/3 allotted Indian owned. A little over 9% of Tract 8, 50% of Tract 14, and 1/3 of Tract 16 are owned by UDOT and administered by the Department of Forestry, Fire, and State Lands.
Okay. As provided in the compulsory pooling statutes, the royalty under the leases covering those Indian and state interests in those tracts are not included in the acreage weighted calculations. Is that right?
That's correct.
Okay. And the remaining tracts, other than those owned by the tribe or UDOT, DFFSL, as mentioned, are those all owned in fee?
That's correct. The remaining tracts are all owned in fee.
Okay, perfect. Exhibit E, probably not a whole lot of time needed to be spent on this one. Can you explain what this shows?
Yeah, this is just a simpler depiction of the mineral ownership and the general location of the PAL 1H well within the DSU.
Okay. And finally, Exhibit F.
Yes, Exhibit F is a DSU working interest owner summary snapshot. Ovintiv is the majority lessee working interest owner in this DSU and is the operator of the PAL 1H well. Additional lessees working interest owners in the DSU were WEM Uinta and WEM Uinta 2 LLC, both of whom Ovintiv has purchased the interest of. Also Salt Creek Oil and Gas, the Janelle Hicks Trust, and IP LLC. All but IP LLC have signed JOAs with Ovintiv, the terms of which contractually govern well elections, including the elections made on the PAL 1H well. Finley Production Company LP also signed a JOA, but has since assigned its interest to Ovintiv.
Okay.
And Ovintiv, as the designated operator, has recorded a pooling declaration, pooling the fee leases pursuant to the authorization contained in their various pooling clauses. Ovintiv has also submitted a communitization agreement pooling these leases with the tribal and allotted leases, but that CA remains pending approval by the BIA.
Okay. Thank you for that. So I guess the short story is Ovintiv owns most of the interest in this DSU.
Yes.
Okay. Now I'm gonna shift you to some exhibits that I'm actually not gonna show. There are a number of them, but I want to direct you to them and ask if you are familiar with them. Exhibits G through R, T through GG, and II through CCC. These are a collection of what appear to be election letters, election packets that you send out. Are you familiar with those exhibits?
Yes.
Okay. And are those official business records of Ovintiv prepared in the ordinary course of business?
Yes, they are.
Okay. And as I said, is it fair to say these are the notices of opportunity to participate mailed out in this well?
Yes, these are the various notices of opportunity to lease and or participate that we sent for the PAL 1H well, along with the proofs of delivery. JOAs and the exhibits DDD and EEE were attached to each.
Okay. And DDD and EEE, those are exhibits you're familiar with and that are corporate business records of Oventives as well?
Yes.
Okay. Exhibit S and Exhibit H are no longer necessary. Can you tell the board why that is, or why they've been excluded?
Yes, they are both the notices of opportunity to lease for Cynthia Smith and Claudia Merthen. But they, as pointed out earlier, they both signed leases with Oventive, so they are now considered voluntarily pooled.
Okay. And each notice mentioned above, each of these notices of opportunity to participate, along with the referenced attachments contained in Exhibits DDD and Exhibits EEE, I'd like to remind the board that reflects the full compliance with the regulatory requirements under 649.1.1 and 649.2.8a, as the board first ruled in March. In the interest of brevity, there was something we discussed at the outset, and I passed around a probably difficult to read exhibit to all of you before this hearing started. What I'd like Mr. Burns to do next, and what we typically do, is go through each of those notice of opportunity, discuss who the party was, when they received it, what tracks they owned an interest in, and what their total interest in the unit is. However, it's information that we believe is just as efficiently communicated in written form, and much more efficiently. So what we've done is prepared and would like to offer to submit testimonial exhibit 1 to essentially talk about that really quickly and move on to the next stage of our hearing. Is it appropriate? Would the board approve me including filing testimonial exhibit 1 and discussing it here?
Yes, that would be good. Thank you.
Mr. Burns, are you familiar with this testimonial exhibit 1? Have you seen it?
Yes, I have.
Let me see if I can pull it up here for us. If you'll indulge. Excuse me. Do you recognize that exhibit, Mr. Burns?
Yes.
And was that prepared by you or under your direction or supervision?
Yes.
To not belabor the point, does this include the full list of parties to be pooled at this hearing today?
Yes, with the one correction that we discussed a little bit earlier with Janelle Hicks being included on here incorrectly.
Okay.
She did sign a JOA and elected to participate, so her inclusion on this list was an oversight, so she will be removed, and I can send a corrected copy after the hearing.
That would be great. Thank you.
Sorry, could I just,
oh, please.
Rather than do this later, can I just get a clarification now? The non-consenting parties in their original request, there was around 50 of them. Now we have a much shorter list. Could I get an explanation how that's being cut down?
Well, we have secured a few leases as we've talked about, and in here we've since we don't have probate documents from the heirs or devisees of those listed, we have just lumped those in as a single entry.
So let me ask a follow-up and see if I can bridge the gap. Is what you're saying is you included some people named in the named parties to be pooled who solely inherited as an, or who solely were named as an heir or devotee of one of the named estates, and you've removed that party?
Yes.
Is that what you're saying?
Yes.
Okay.
Mr. Mayo, are you intending on submitting all of these exhibits individually or only this?
I believe we'd want all of the exhibits admitted to the record,
Okay.
but they're all there. They've been authenticated.
Okay.
We just don't need to testify about each one. This is kind of a summary exhibit.
Thank you.
What that testimony would have been, if that clarifies.
Great, thanks.
So I guess to answer, Andrew, did that make sense, that answer?
Yeah, so if I understand, the original list, I mean, these are exhibits G through CCC. That is every individual party, even people we believed were heirs and advisees. But in this exhibit, we have consolidated the heirs and advisees under just the estate.
Yes.
Okay.
And taken a significant number out, or a handful out for leasing, confirmation of probates, et cetera.
Okay.
So, Mr. Burns, returning to this testimonial exhibit I, is it your testimony that these parties, minus Janelle Hicks, referenced in the middle, that these parties own interest in these tracks and it equates to the named percent in the drilling and spacing unit assigned to them?
Yes.
Okay. Thank you for that. Have you received any responses, again, aside from Ms. Janelle Hicks, have you received any responses from any of the parties identified on this list with respect to this RAA seeking to participate or lease their interests?
No, we have not.
Okay. Turning, if I can, your attention to Exhibit DDD. Let me see if I have a visual of that, or if we just go. I don't believe I do. As you referenced, the election letters had two attachments with them, Exhibits DDD and Exhibit EEE. Exhibit DDD is the survey plat for the Powell 1H well, is that right?
That's correct, yes.
Okay, and then Exhibit EEE, what is that?
Exhibit EEE is the AFE that was sent along with each notice. As Mr. Wall will testify, the AFE was a fairly close estimate of the actual costs incurred in the drilling of the Powell 1H well.
Okay. I'd like to have you briefly discuss the estates, if you could. And I know we've already discussed it. Can you just, there's no reason to necessarily discuss each of the estates. Can you quickly hit on the board for them one more time? Which estates have been removed from this since filing of the request?
Yes, so as Mr. Mayo mentioned, several lessors claim title in these lands through one or more of the estates. And there are several of those. As we talked earlier, we did locate final probate for Lane Nielsen, and his two heirs have leased to Oventive, so he is being removed from the list. Otherwise, there are several others that remain on here that will need to remain due to unprobated estates or no final distribution of that estate.
Okay. Thank you for that. And again, standard practice, you believe you have all of the heirs or devisees, or the majority of the heirs or devisees located and leased, but out of an abundance of caution, in the absence of a conclusive order, they're included in this request.
Correct.
Okay. I'd like to just point to replacement exhibit GGG, the proof of publication, to demonstrate to the board that notice was published in this cause as ordered. I'd like to briefly address the IPLLC leases, if that's okay. I don't want to get too much into the weeds. To remind the board, how is IPLLC involved, and who is their lessor? Who have they leased from?
The IPLLC is the lessee of James Reeder and Patricia Reeder Eubank, who own interests in tracks 6 through 8, and of UDOT and DFFSL in tracks 14 and 16, which equates to an aggregate 2.9882% working interest in the DSU as reflected on Exhibit F. The Reeder Eubank leases provide for an 18.75% royalty, while the UDOT DFFSL lease provides for a 1/8 royalty.
Okay.
IPLLC is a consenting owner in the Powell 1H well, but has refused to execute a JOA and therefore must be compulsory pooled. As a consequence, its lessors must also be compulsory pooled or, as relevant to DFFSL, at least provide its written consent to being pooled once IP LLC is compulsory pooled as required by statute.
Okay. Thank you. So another way to say that is IP LLC is included solely for imposition of a JOA in this case.
Yes.
Let's move on to the JOA terms then. I don't have a visual of this because it's fairly repetitive and we've seen it a number of times, but I want to talk about a couple specific spots in the JOA. Exhibits FFF, HHH, and III. Let's start with exhibit FFF. Do you know what this exhibit is? Are you familiar with exhibit FFF?
Yes, it is an exhibit. Exhibit FFF is an official business record of Oventive. It is the JOA that was attached to the Notice of Opportunity to Participate.
Okay. And HHH and III. What are those, and are those were those prepared by you?
Yes. Exhibits Triple H and Triple I are standard industry forms supplied by the AAPL Form 610 with modifications. This is the 1989 version with modifications to address horizontal wells. Exhibit Triple H is materially the same form JOA sent with all of the mailed notices previously outlined. Exhibit Triple I additionally reflects Oventive's capitulation to all of IP LLC's objections as outlined in Exhibit Triple F, except for Article 16K.
Okay. And when, in your opinion, are the terms and conditions contained in this JOA or these two iterations of the JOA consistent, commonly found, something you've seen and experienced and been engaged with in the basin?
Yes, the terms and conditions contained therein, including the modifications made, are consistent with and commonly found more recently developed horizontal well drilling units, including the JOAs signed by the other voluntarily pooled working interest owners in this DSU. Oventive has prepared identical terms, for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
Okay. And page 7 of the JOA addresses the non-consent penalty. What is the non-consent penalty in the JOA you're seeking to impose?
Yes, in this JOA, it's a 100%, 300% non-consent penalty, which is the same as what is contained in the JOA signed by WIM and all of the other parties who elected to participate and sign JOAs in this unit.
And since you've acquired, if I remember your testimony correctly, you've acquired WEM's consenting interest in this unit, or maybe it was Finley's, maybe both. If they consented and signed the JOA, effectively you've agreed to both sides of the JOA in this matter, right?
Yes.
Okay. And Exhibit C to the JOA, the COPUS, the board's fairly familiar with this, but we hit on the key points.
Exhibit C of the JOA is the COPUS accounting procedure. Again, this is a standard industry form, almost universally utilized, similar to other JOAs in the Uinta Basin. The key points here are on page C3. Article 3B sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%, which has been deemed fair compensation and to encourage timely payment of chargeable costs and expenses. And the last key point is found on page C9, which outlines the overhead charges of $10,090 while drilling and $1,090 while producing.
Okay. A couple more questions, if I could, on this. Given IP LLC's failure to respond to the REA and the board's reservation on the ruling in the partial summary judgment motion, It appears that there's no longer dispute as to the terms of Exhibit III, the JOA that you described as the capitulation to IPLLC's JOA modifications. Do you concur that there's no longer a dispute over those terms, that IPLLC has essentially withdrawn its concerns, and that the board is within its rights to rule on the partial motion for summary judgment and approve this request?
Yes, I believe so.
Okay. In your expert opinion, the terms and conditions of this JOA are fair, reasonable, and consistent with those accepted by other operators?
Yes.
Okay. Finally, before I let you go, I want to talk a couple more things quickly. Acreage-weighted royalty, and I actually have a visual here for that. It's Exhibit JJJ-1 and JJJ-2. Oh, it's just numbered. Exhibit JJJ. Do you recognize this exhibit?
Yes.
Did you prepare this?
Yes, I did.
Okay. The board's seen plenty of these. Couple things I'd like you to confirm. One, can you confirm that you removed all non-fee leases, all federal, tribal, state leases that were entered into, and any leases that were entered into after the spud of the Powell well from this calculation?
Yes.
Okay. And what is the acreage-weighted royalty that you're seeking to have imposed today?
Based on the calculation shown here in this exhibit, the average weighted fee royalty is 18.046128%.
Okay. And lastly, notice, I want to refer you, Mr. Burns, to the certificate of mailing and the supplemental certificates of mailing on file in this cause. Are you familiar with those?
Yes.
And do you know, can you tell the board quickly who those people are that are on that list and how you derived at that list of names?
Yeah, the people shown are all of the production interest owners within sections 5 and 6. The addresses were derived from a title opinion, which was effective as of June 9th, 2022, as updated by a search of the county records by Lone Wolf, our land broker, along with our own internal records.
Okay. And I'd just like to refer you, Mr. Burns, and the board to replacement exhibit NNN as supplemented. I'm not even sure what it's called at this point. The true and correct copies of the certified mailing receipts received by Lear & Lear, which exhibit was filed just a day or two ago. That exhibit demonstrates proof, confirmed receipt of the mailings at issue here today. Mr. Burns, is there anything we forgot or anything we need to address or you'd like to say before I turn you over to the division?
I believe we've covered everything.
Okay. With that, I would turn the time over to the division and board for questioning.
Thank you. I don't have a specific question, but if we went back to Exhibit F, could we get that updated, the compulsory pooled interest to now reflect the actual parties?
Yes.
Because the one we circulated in the testimonial Exhibit 1, those are a little different, and I assume those differences are from the now leased parties, but if we just get that updated. On that, the division has no questions.
Okay, thank you. Any questions of Mr. Burns from the board, or should we move on to Mr. Wall?
Board, do you have any questions at this point? No questions from the board.
Okay. Mr. Burns, you can stand down now. Please don't leave. Pay attention because you may have follow-up questions here at the end. Mr. Wall, are you there and can you still hear us?
I am. Can you hear me?
Yeah. How come there's a new landman every time? They only have to do one, but you're here all day long.
No. Efficiency on the engineering side.
Go figure, huh? Mr. Wall, one last time, could you please state your name, spell your last name, and your business address for this record.
Yes, my name is Chris Wall, Woll. Business address is 4 Waterway Place Avenue, The Woodlands, Texas 77380. I am a senior reservoir engineer working the Uinta asset for Oventive.
Okay, thank you for that. And I'm assuming that includes this particular unit.
Yes.
Okay. I'm going to show you what's up on the screen. It's been filed in this cause as Exhibit K, Exhibit Triple K. Can you walk the board through what this shows?
Yeah, this is the summary of the actual costs incurred in drilling and completing the Powell 1H well. And this is a cost through June 30th of 2023.
Okay. Based on your experience, are these within a reasonable variance of the AFE costs sent to the electing parties?
Yes.
Again, in your expert opinion, were these costs fair, reasonable, and necessarily incurred, and was the well deemed economically feasible?
Yes.
Okay. Now, Oventive typically estimates plugging and abandoning costs of around $75,000. Is that Oventive's estimated plugging and abandoning costs for this well?
Yes, it is.
Okay. And that's based on 100% working ownership, 100% working interest ownership?
Yes, that's correct.
Okay. Thank you. Two more exhibits, if I may. Exhibits LLL and exhibit MMM. And do you recognize these two slides?
Yes.
And were they prepared by you?
Yes.
Thank you. Exhibit LLL. Please tell the board what's important about this slide for them to know.
This is a plat of the nearby existing horizontal wells at the time the Powell 1H well was spud. And this well was concurrently drilled with the other laydown wells in the area. And there was limited or no well control at the time of spud.
Okay, so there looks like there's a lot of wells around there, but what your testimony is those 4 wells, and I'm going to guess it's the LaPrade, the Powell, the Wolf, and the Moon wells, were all drilled simultaneously, meaning you didn't have any previous well results nearby.
We did not have any, previous well results on laydowns nearby.
Okay, thank you for that. And exhibit MMM, I'm assuming this ties into the risk assessment. Can you talk through the risks here, not just the drilling risks, but the operational and kind of the practical financial risks that you encountered?
Yes, while the risk of drilling a dry hole is lower these days, developing oil and gas assets is still a very challenging and risky business. The cost of drilling and completing wells is high, so there's a high capital burden, and it can be uncertain with operational challenges such as stuck pipe and casing with the high clay zones that are encountered in the Uteland Butte formation. In this particular area, production expectations come with higher uncertainty as there were no laydown oriented laterals for a basis. And lastly, the volatility of oil prices. Economics of oil and gas wells are sensitive to oil price, and the volatility of prices subjects oil and gas investments to high economic risk.
Thank you. Mr. Wall, anything, in your expert opinion, is a 300% risk compensation award fair, reasonable, and necessary in this cause?
Yes.
Okay. Thank you for that. Mr. Wall, anything you'd like to add before I let the division and board ask you questions?
No, I'm good.
Okay, thank you. Turn the time over to the division.
We have no questions for this witness.
Board, do we have any questions?
Yeah, can we go back to LLL just a minute? I'm just trying to figure out what's that little, you got the 2 parallel well bores, and then you've got some little strange little feature there. What's that?
I think I know what you're talking about. Let me see if I
Yeah,
can
it's a
zoom.
little, looks like a little point to the left.
This little thing, or this, is it the
The one right in the middle, right in the southwest of 6, or right by the southwest of 6.
is that the well pad, Mr. Wall? Is that kind of indicating the direction? Is that about where you located the surface location for these wells?
Yeah, so that surface location is in that section 1. Section 1, the numbers covered up by the Lepre there. So it's in that southeast corner, if that's what you're referring to. I can't tell exactly what you're pointing to, but
Yeah,
those
so that's like the pad
lines.
for like 4 wells or something like that. or
So you
at least
drilled
2
all
wells.
of these off one pad, and those little
Okay.
lines, angled green lines going to the wellbore paths, those are just indicating from that well pad to the wellbore. Is that?
That's right. So, in the case of the wells like the Lepre and the Wolf, you actually drilled, or we drilled east and then turned and went back to the west.
Okay.
And that way we can maximize the lateral length within the sections.
Okay.
So that's what you're seeing.
Thank you, yes. Nothing else.
Do we have any other board questions? Okay. Back to you.
Well, I think now is probably an appropriate time to move for admissions of this this list of exhibits. I'm going to go through somewhat slowly.
Let's go slowly, please.
Hopefully Julianne can keep us all on track as she always does. I would like to move, well, let's put it this way. I'm going to start by saying the exhibits we don't need are exhibits S and exhibit HH. So I'd like to move for admission of exhibits A through R, and then T as in Tom, through double G, and then skip HH, and I'd like to move to admit double I through triple N as supplemented.
Exhibit F is to be revised. Do you have a note of that?
In addition, we will be submitting after this hearing a revised Exhibit F, as well as a revised testimonial Exhibit 1, which I also would like to move for admission of here.
Okay, and triple G, which was the proof of publication, has that been, replacement exhibit GGG, has that been submitted? It's the proof of publication. It says reserved to be filed once received from the Uinta Basin Standard.
Yes.
That has been,
I believe that has been, but if not, we'll make sure it is filed.
oh, Maddie said we do have it.
Okay,
So
perfect.
that's-
Thank you
that's
for that.
okay.
So I'd like to move for admission of, again, exhibits A through R, T through double G, double I through triple N, and testimonial Exhibit 1. To be corrected.
So admitted.
Thank you so much. In conclusion, the statutory and regulatory requirements, although complicated and voluminous, have been met. Notice was provided to all parties, and I guess most importantly, in some senses, from this board's perspective, the party who has expressed the most concern about this was given full notice of this, was given every opportunity to appear and participate, was actually sent a copy as well of the partial motion for summary judgment that's pending disposition, and has chosen not to participate, not to object. I think the clear implication is that the parties to be pooled should be pooled, and that the terms of this request are fair and just. And on that, I'd request that the board approve this request as pleaded and as conformed to this testimony here today. I'd like to thank you for your time and attention.
Division, do you have any concerns or comments?
We'd just like to add that based on the testimony we heard here and the fact that we are unaware of any parties objecting to this request. The division is in support of it.
Board, are there any questions or anything you'd like to? Okay. This is a little unusual, Board, but we will need to have a motion on the partial motion for summary judgment on the International Petroleum. Do we want to grant it or not? I think, yeah, because this is a little out of the ordinary, I think maybe we need to talk.
I'd like to remind the board before you do that, this is an identical motion as was filed and granted by this board a couple of months ago.
Okay.
Identical motion, identical letters, identical motion, the
Okay.
names have been updated. Undisputed, unopposed, and genuinely, without resolving it as an approval, as a granting of that summary judgment motion, we'd probably have to go back and have another couple hours of testimony.
Yeah, can you just give us maybe 15 minutes just to,
But why do we need this summary judgment if we just, if this were to be improved, isn't that just take care of it?
That is absolutely an alternative way to go about it. As you're all aware, Mr. McDonald is primary counsel typically for Ovintiv, and most of this was prepared by him before in June. So I think, speaking from my perspective legally, absolutely. There's nothing, which is why we kind of chose to reserve it till the end. There's nothing that we can't resolve in the order on the request for agency action that needs to be resolved in the summary judgment motion. But having said that, I would hate to say we don't need it and not know why he thinks we need it, if that answers your question. But regardless of what he may prefer, he's not here today, the board is, and the board has full authority to say, we approve the request as pleaded, and we intend to impose this JOA, and we ignore their objections.
let us talk about it for just a minute. We'll come back and we'll try 10 minutes.
I'll be here.
Okay, thanks.
Thank you.
We're off the record. We're back on the record. We have talked, and we think we can resolve this with a motion. So if we could get a motion from the board.
Yes, Madam Chair, I move that we approve the RAA as requested, and in addition, grant the motion for partial summary judgment.
I'll second.
All those in favor?
Aye.
Any opposed? And we have one abstention with Mr. Moon.
So is that 4-0 by my count?
Right. We do have a missing board member, so. Should we do a roll call? Okay. We are good.
And I am very happy. I know what you were going to ask next, and I'm very happy to prepare the orders if you'd like. Sorry to cut you off, but I knew you were headed there.
Took
so.
the words right out of my
That's
mouth.
right.
Thank you, Mr. Mayo.
You're welcome. Thank you.
All right, let's see where we are here. So now.
Thank you, everyone.
We're going on to the XCL matters.
That's right.
7 and 8.
Do you have any slides? Okay. All right, we're moving on to docket number 2023-040, cause number 132-22, in the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Co., LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280-acre drilling unit established for the production of oil, gas, and hydrocarbons from the lower Green River. And I believe this was a hearing examiner situation, and Ms. Harris will fill us in.
Yes, thank you. John Rogers of the Division of Oil, Gas, and Mining served as the hearing examiner in these proceedings, but he is out of town, so he has asked me to report. I represented him as his counsel. We did have a hearing examiner proceeding last week. Mr. Rogers reviewed all of the filed exhibits. He reviewed carefully the request for agency action. There were no opposing parties to the matter. The division filed a notice of non-opposition. Mr. Rogers reviewed the testimony and asked questions of the witnesses, and based on the proceeding, felt like XCL had met the statutory and regulatory requirements for compulsory pooling. Mr. Rogers specifically found that XCL had provided proper notice and a notice of opportunity to all the unlocatables and the non-consenting parties. He found that those individuals should be deemed non-consenting owner as contemplated by the statute. He found that a 300% risk compensation award was appropriate and justified based on the facts of the case. He found that the terms of the proposed JOA were just and reasonable and recommended that the board adopt that JOA as governing the dealings between the parties. And he found that the compulsory pooling of the consenting owners and the non-consenting owners would promote the public interest, prevent waste, and protect the correlative rights of all owners. And so he has prepared a recommended order that he has signed and submitted to the board, recommending that this request for agency action be approved.
Thank you. Does the division have any comments?
No, I don't have any further comments.
Board, are there any questions?
Are we ruling on one cause or both causes?
Or just one?
Just the first one.
Right, the first one. Do we have a motion from someone?
So I would move that we approve the hearing examiner's recommendation to approve this order.
All in favor?
Aye.
Any opposed? Passes unanimously.
Thank you.
Thank you. This says Richard Ford. Changed. Go to the next one. Oh, all right, we're moving on here. Docket number 2023-041, cause number 132-23. In the matter of the request for agency action of XCL Resources, XCL on behalf of XCL Asset Co. LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2560 acre drilling unit established for production of oil and gas from the lower Green River Colton formations. Ms. Harris, please.
Thank you, and I apologize in advance for being a little repetitive here, but we'll create the record. Mr. Rogers was again the hearing examiner in this proceeding, and since he is unavailable, requested that I report to the board. We had the hearing examiner proceeding last week. Mr. Rogers reviewed the request for agency action, all of the exhibits that were filed, the testimony, asked questions of the witnesses. We had discussion on a few items. Based on the evidence that was presented and the documents presented, Mr. Rogers determined that proper notice was provided to the unlocatables and the non-consenting parties, and that those parties should be deemed non-consenting owner as contemplated by the statutes and rules. He found that XCL had met the regulatory and statutory requirements for compulsory pooling. He found that a 300% risk compensation award was justified and fair under the facts of this case, that the terms of the proposed JOA were just and reasonable, and recommends that the board adopt that JOA to govern the future dealings between these parties. And he found that the compulsory pooling of the consenting and non-consenting owners would promote the public interest, prevent waste, and protect the correlative rights of all owners in this area. And so with that, he has prepared a recommended order, which he has signed for your review and approval.
Any further comments from the division?
No further comments.
Any comments from the board? Mitch?
Oh, for me, yeah. One comment, and that is just to thank the board and division. I know hearing examiner hearings can be a hassle. However, I think we all can agree if we had 2 forced pooling matters ahead of us right now, we'd be pulling our hair out. So it's a lot of work, and the division staff did a great job. I think it worked fairly well as far as for feedback for the board, and we're looking forward to trying to improve upon that process again next month. So thank you.
Thank you. Let's go back to 132-23. Did you have a comment?
Just on both of them. They weren't streamed on YouTube, and I know that has to do with this room not being available or whatever.
Yes. So with the new hearing examiner process that we're trying to put into place, we're trying to accommodate some of the resource issues that make it difficult for the division to hold these proceedings. Because of that, we have to hold it into a different room, and so we record those, and we post the recordings on YouTube, but they aren't live streamed. It'll just be afterwards.
Just like media, like they're there now then, huh? Or
Julianne would know. It might take a day or so to get there. I'm not sure how quick they come up.
Okay, yeah, that's fine. A day or 2 later. It'd just be nice to be able to watch them if I have time before this, before the actual hearing.
Yeah, we're experimenting a little to try and refine this process. I think I'm optimistic we're going to get this down pat, and it's going to be really great going forward.
Great. Board, do we have any other comments? Can I get a motion?
I would move that we also approve this request for agency action, the hearing examiner's recommendation.
A second?
I'll second.
All in favor?
Aye.
Any opposed? Was unanimous. Thank you.
Thank
Pass it
you
on to
very much.
Mr. Rogers. Thank you. with that, you know, I think we are done.
Make a motion, we adjourn.
I'll second that.
Motion
I'll
passes.
third that.